Also, may I permit mention on restoration application? Restoration application.
Where is your notice?
Group 2.
Notice.
Notice, I have seen.
Give a notice and come. Yes.
Group 2 application, man.
New application.
Fresh.
Yes. New applications hand over the slips.
Lordship,
one new applications.
one application.
New.
Yes, my lord.
Yes, my lord.
2021.
So then,
My lord, this is assigned. This is assigned before your lordship.
when was it assigned?
Before summer vacation, it was assigned.
Before myself and Justice Chatterjee.
Presided over by your lordship.
Please see the file. Did we hear it?
This is hearing matter.
Please check up the records and mention. Give a notice to your other side.
Lordship.
My lord, may I have your lordship's kindly, my lord, to seek my lord leave to file my lord a review without my lord the certified copy.
So
Lordship's order was
not allowed. Review without certified copy. Please do not embarrass us.
I would not.
To obtain the certified copy, you have difficulty in the department. Immediately report it to the registrar.
I bow down to your lordship's observation, my lord. Only, my lord, the difficulty is, my lord, the incumbent who is there is bound to retire on, my lord, very soon, my lord, tomorrow.
Very good. You obtain
my rights.
Obtain the certified copy and file the review. Review of our order.
Order of, my lord, 7th of August. My lord, we have just been received instructions.
Get the certified copy. We do not allow. Yes.
New application, lordship, inclusion for the list, lordship.
New application.
Yes, lordship.
Your lordship, it's an urgency of hearing.
Huh?
For hearing, your lordship.
Madam, no hearing mentioning, don't give it. Come later.
It's urgent, your lordship, because my client here is a TET aspirant. Like SSC exam will be conducted. The SSC exam will be conducted.
Your appeal is of which year?
2025.
So 25, you did not get the interim order. The appeal is now to be heard. What urgency? If the interim order was refused to you, did you come up against any interim order? Sir, madam, please go through the file and then mention. Don't listen to what your clerk says. You are a counsel. Please go through the file, get yourself satisfied. Then the questions which you are putting, you can answer. Please go through the file and come give a notice and mention. Yes.
In this matter, my lord, this appeal was heard on last Monday, and my lord, an order was passed. My lord, I represented, my lord, to the respondent number 6, Union of India, my lord. But my lord, inadvertently, my lord, my appearance is not recorded, my lord. My appearance is also not.
By reason of a typographical error.
But I'm for the appellant. Oh, I'm sorry. I'm for the respondent. This is the habit.
I'm for the one of
I'm
the
for the
applicant.
respondent, my lord. This is the state's appeal, my lord. A question which is very pertinent, lordship, that is has
Come up
been
for
raised.
extension of interim.
Yes, my lord. My lord, kindly fix a date for hearing.
Well, there
I
is
will-
another contempt issue pending before the Honorable Supreme Court fixed on the 1st of September. That particular contempt issue is with regard to the non-implementation of the NALSA judgment with regard to the transgenders. And
Well,
the issue here, my lord, is if not identical, but is intertwined.
It is not exactly intertwined, my lord.
The last order
We
passed by
wanted-
Division Bench of Justice Showman Shen, my lord.
What we wanted, lordship, we wanted the reservation for the transgender, 1% horizontal reservation, which was given by the honorable single bench. My lord, that has
So
not
that
been given.
Contempt application is still pending.
On 1st of September, it is supposed to be listed, my lord.
My lord,
Before.
that may be a different contempt, but lordship, this is a question.
For whom?
I am for the lordship respondent, that is the petitioner, writ
Writ
petitioner.
petitioner
My lord.
is-
But there was a direction to give me a job. I'm a transgender, participate
You
in
have
the.
to await the decision because that is the observation of the court.
My lord, kindly keep the matter pending and fix a date so that we can come back.
Date cannot be fixed, liberty to mention we will give.
Miller.
Ashok. Mr. No. Mr.
বুঝছি একসাথে
Yes. এই যে মান ওগুলো ঢুকিয়ে দিও না, সব ঠিক করে ঢুকিয়ে পড়ে। তাই জন্য your other side.
There was a direction to serve.
You're for the state.
School Service Commission.
You know, give us.
Service is complete, my lord. My lord,
What is the date of the ordering?
15 July 2024.
Have you annexed it in your stay application?
Yes, yes.
Where
Page
page?
63. Page 63. Rules গুলো দেখি, rules গুলো।
In medical transfer on medical ground, there is no clause to.
There is no rule. Rule 62 DC. Rule 62 DD says in case of medical transfer, student-teacher ratio will not be a bar. My lord, kindly take. I have marked for your lordship this the rule. Lord, kindly take rule 62 C, D, and E.
Rule 6
2D, E.
of which notification?
Notification 8 September 2021. I have marked for your lordship's convenience. This
8 September
2021. Six, 2, C, and E. Amended rules, yes. Petition থাকে এই petition নেই এটা change to it.
Where is it?
But I have marked for your lordship.
It is not in the mark.
Yes, I've handed over one copy. I've handed over one copy.
So I'm looking at your book.
Another copy is there, my lord. এই কপিটা একটু দিয়ে দিন না সামনে
This was pre-
no this one
You had previously handed over, Mr. Knight.
previously it is there. No, this voluminous bunch that I just handed
Sure.
over. Yes. The two sets I have handed over. Yes.
Where is your marking, sir?
That flag, my lord, kindly see 62C.
Okay, দেখাও আমি দেখতে পাচ্ছি।
And then
আগে একবার দিয়েছিল সেটা থেকে দেখছি।
I'll just flag it. Page 21, it is. My lord, kindly take the middle portion 62C.
Just a moment.
Yes. The green flag.
So in case of an application under rule 4, place the rule.
Kindly take the previous page at the bottom. Rule 4 at the bottom.
Yes.
Any incumbent or his son, daughter, spouse suffering from malignant disease, severe heart disease, renal failure, thalassemia, replacement of organ, serious gynecological disorder causing serious problem in attending the school. Rule 4 considers the medical grounds, and 62C says
4A considers medical ground.
Rule 4A at the bottom.
Yes.
Yes. And
A, B, C, D, E.
yes, I am under Rule 4A.
No, grounds of transfer may be medical,
Medical.
permanent disablement,
Yes. Then
female in. This is a transfer on medical
ground.
Where
Yes.
do we find that?
Well, kindly see 4A. Any incumbent of his spouse, daughter.
Suffering from such and such.
Yes, medical ground. I made on medical ground application. CD is not applicable for me. 4A is applicable for me.
BCD
No,
is not
No,
applicable.
that is not on medical ground. 4A is only on medical ground. So I applied under 4A on medical ground, and rule 62C and E says if it is on medical ground, student teacher ratio.
That's it. 2C. 2C is about the roll trend.
Yes, it imposes a bar.
Hmm.
Now E relaxes the bar. Dispensed with the provision of clause C and D of this sub rule for application made on grounds mentioned in rule 4A to D.
After this, any further amendment?
No. This is the last
So
one.
when was your application for transfer?
That was after 8th September.
So in case of medical, what will be the follow-up step taken?
11.
My lord, the school authority kindly come to page 50.
50.
50
Of
of the
your stay.
stay application, my lord. I applied on 8th of November 2021. The school authority returned.
Then ultimately, it was forwarded to the applicant,
Yes, back.
forwarded to HUI.
HON.
Next,
Then-
HUI sends it to no sufficient.
No sufficient teacher. That is also recorded in the order of the learned single judge. So on that
And
ground,
then it was forwarded to
backwarded. Then after suspension of portal,
then what is the first one?
first one is after that, again it was forwarded, but on the same ground, since it has been rejected, the school authority did not take any step. And subsequently, the portal was put under suspension. So, my lord, that was challenged before the single bench on medical ground. The rule says 62C and E.
Now, they show us how it will be processed, your application under
Yes.
rule 4A.
4A, my lord. My lord, kindly take the rule I handed over to your lordship. Kindly take 62 The rule 6 gives the procedure for submission and consideration of the application. Page 21 of the rule.
Hmm.
Rule 6, amended rule 6.
Read.
Yes, my lord. An incumbent may apply for transfer on grounds and manner mentioned in Rule 4. The respective authorities involved in the process of transfer, i.e., the School Managing Committee, District Inspector of Schools of Secondary Education, DI, Central Commission, West Bengal Board of Secondary Education, shall consider such transfer application within such time as may be specified by the state government by guidelines. 2. Upon submission of application, the authority of SMC shall verify the service records and other details of applicant. B. Examine whether departmental judicial proceeding is pending or being contemplated or suspension order is issued against applicant or not. In any such affirmative case, the school authority shall not forward the application. C. Consider the numbers of subject teachers and roll strength if resultant vacancy of the school in particular subject becomes 0 or not commensurate with roll strength. The authority of SMC shall not forward the application.
Very
D.
good. Now, dispensed with in respect C and D dispensed with in respect of grounds in 4A to D.
A to A.
Very
Fine.
good. Now,
Yes.
if that is dispensed with, how the school will proceed?
The school will now conduct an BMOH
Where
verification.
is that?
Yes, it is laid down subsequently, my lord. My lord, kindly take F. Cause to examine the applicant by the doctor of the SMC. In case of transfer application made on medical grounds mentioned in clause A of rule 4 and must indicate the disease of the applicant which caused serious problem in attending the school.
So, where did you indicate in your original application?
No, that stage did not go. School, first of
No,
all,
when you submitted the first representation,
yes,
which was returned back,
yes.
show us that application where what medical ground did you state there?
A serious gynecological problem, my lord. I had
Show us
stated,
that
yes,
application which was uploaded in the portal.
yes, that was my lord.
Page.
I'm just giving, my lord. Kindly give me a moment.
That was of 8th of November 2021, which you uploaded in the portal.
My lord, the medical documents are annexed from
No, we are not. Please answer our
Yes, yes, yes.
question. Don't take us.
No, no.
Show us the app. Is it, if it is there, you point out, and if it is not there, you tell.
No, these are the medical
Page.
page 43 onwards. These are the documents which were uploaded. And my lord, after that, this,
No, uploaded document uploaded. Very good. Where is your application?
that is the portal application. There is no application. It is online.
Yes.
Online, I need to make the application. There is a button. I click, then I upload the documents, medical documents. It goes to the school authority. School checks it. Now the next duty of the school is to conduct a BMOH verification by the school authority. Upon finding the report, if school is satisfied, school sends it to the DI. Now DI conducts another CMOH verification. Then if DI is satisfied, then it is sent to the Central School Service Commission for taking decision. This is the whole procedure. So I was stuck in
Just a moment. Now thereafter what? F says
if says that
cause the examiner cause
examination has
to
to be done,
examine
then
by
NOP,
the doctor of the SMS
Isn't-
SMC.
yes,
So SMC will have you examined.
yes.
Acha, and must very good.
Then my lord, upon being satisfied with the medical report, they will issue the no objection G
where is upon being satisfied, issue in fit cases.
fit cases and shall forward transfer application to the DI of schools. I did not reach to that level. School only stalled me at the very first stage without conducting any medical verification.
Very good. Then when did you prefer the writ petition?
When did I prefer the writ petition?
You waited for how many years?
This is of 2022. Writ petition is of 2022 itself.
Writ petition was of 2020.
2022. Yes. So I'm clearly covered by 6 to C and E. E says that medical ground will not be a ground. And my lord, the
Has there any been subsequent amendment to this?
it is there.
Yes. What do you say?
My lord, I'm for the commission.
Uh,
My lord,
Now, what is Mr. Lydi, what he is submitting? Upon hearing it appears there is no barred in considering, because those two portions have been dispensed with.
My first submission is kindly come to once page 50
One
of
five,
this stay application. 50.
1 5,
50.
50
50. Your Lordship have already seen.
application.
The status of the transfer application in the Ussosi portal.
Pardon?
Status of his transfer application in the portal. Now, my lord, your Lordship will see the serial number 3. That is his first application made on 8/11/2021. That was backwarded or rejected by the school authority, and it was returned to him with the remark that no sufficient teacher or on that ground.
Thereafter,
Now, my lord,
thereafter he made a further representation.
Further application. So, as on today, officially, a transfer application is pending before the HOI. That is the school authority. So, the moment he has preferred another application, he has foregone in my respectful submission, he has not challenged that rejection of the first application. Once he has made a further application, he cannot challenge the rejection of the first application, the first application after making the second application. Now, here, the consideration is being made in respect of the rejection of the first application. In my respective submission, that is not permissible. But he has foregone that right.
No, is there any provision under the rules? Mr. Lady, take your seat. Please take your seat. Is there anything under the rules that in such cases another procedure has to be followed?
No, that is not. But my lord, my submission
The
is
first application has culminated in a rejection,
rejection.
and rejection on the ground no sufficient teacher.
My lord.
So if we find that ground is itself bad,
but he has made a further application.
right? So further application is a reiteration of what he has said in the first application.
Yes, that has not been rejected. That is pending. That is still pending before the school authority. In my respectful submission, my lord, once he has made the second application,
Very
he
good,
cannot.
very good.
That will not.
So you can say that at best you can delay consideration of the second application.
Because it is still pending. Let that be decided.
So that does not change the fact scenario, Mr.
My lord,
Wambal.
the present status.
Argument which you are making, that having no sufficient ground, he ought to have
No, my lord,
challenged
this
that.
rejection, kindly consider, my lord, this rejection was made in the year 2021.
Yes.
Now, my lord, the situation may have changed.
Now,
Situation, the staff pattern, that might have changed.
even if that is not a requirement under the.
Yes.
Then
The ground, my lord, the ground for rejection of the school authority was that there was no sufficient teacher. Had he been transferred, there would have been no teacher in that.
to sit down.
Need to take a medicine. That's why I'm seeking leave to just take a medicine and come back.
Yes.
That much only.
Acha, this no objection is to be given. This no objection, there is any pro forma.
My lord, in case of medical, the transfer application on medical ground, whether it is self or spouse medical ground, my lord, the school authority is to consider and issue no objection. In case of medical, my lord, the school authority may have, my lord, examine the applicant by the SMC doctor or by PMOH. And if the report is satisfactory, then my lord, the school authority will forward it to the my lord, concerned DI of schools. DI of schools, in case of medical application, my lord, he will examine the applicant or the my lord, spouse by the my lord, concerned CMOH.
Your school has been served. এই দেখো তো ability of service.
My lord, in the concerned rule, my lord, kindly see the proviso is also applicable.
Which provides
My lord, the rule that has been placed by my learned friend, my lord, the rule, the amended rule 6.
yes.
Your lordship has seen that the rule 2E. Now, there comes the proviso.
Wait, to rule
2E. Your lordship has seen the dispense with the provisions of my lord.
yes, place
C
the
and D.
proviso.
Then my lord, the proviso comes provided that while considering such applications, if resultant vacancy of school in particular subject becomes 0 or not commensurate with the roll strength, the SMC shall approach the CSSC through DISC.
That does not debar consideration
Not
of his
deferred,
claim.
but my lord, here the school authority is under obligation to approach that it does not
It is
mandate.
only after the medical ground is ascertained upon referring it to the BMs. That
Yes,
state comes later.
yes.
If the medical report goes in his favor, then the SMC will immediately approach that if it is a zero, this clause which you have shown,
Yes.
in respect of 0 or insufficient teacher, they shall immediately approach the CSE for filling up that vacancy.
But usually, my lord, what the school authorities are, my lord, were doing, they were directly forwarding the cases to the DI. DI was, my lord, examining the applicants through CMOH. My lord, this BMOH or, my lord, the doctor of SMC, that stages were not being, my lord, executed or, my lord,
Ashok,
exercised.
the subsequent, that
Well,
was also online.
Yes. My lord, one more thing, my lord, your lordship was asking me, my lord, that stage comes later after consideration. Kindly see, my lord, my lord, the clause, my
No,
lord,
Mr.
sub-rule F.
Huh?
No, my lord, sub-rule F, my lord,
Uh.
the examination of the applicant by the, my lord, the SMC doctor, that stage comes later. Kindly see, my lord, clause
Later for after what?
after, my lord, this consideration in my lord, sub-rule F. To F,
yes.
cause to examine the applicant by the doctor. If after consideration the school authority found that these are,
Yes.
so my lord, the school authority has considered the roll strength was not commensurate.
Not on medical ground, Mr. Bandyopadhyay.
No, my lord, the proviso comes after that.
But see the reason, no sufficient ground. See the
My lord,
reason. in there.
that part is, my lord, is not
That
appearing.
on that
Whether
basis-
ground or no sufficient teacher, that we don't know because it is missing.
So what more
Anyway,
it can be?
No, my lord,
No sufficient what it can be. Fill in the blanks what it can be.
yes, teachers. teaches. Now, my
We will
submission is,
ask, this is.
the proviso comes after the dispensation.
No, this passing of in writ petitions, these people are playing with the court because they are not doing the duty. We will not dispose of the epic. We will ask the school authority to send all the records to the concerned BMOH in terms of the rules and to obtain report from the said officer and file a report before us. If medical ground he is not entitled, we will dismiss his matter. And if it is entitled, we will consider whether we will set aside the order of the single judge and direct the authorities to take follow-up.
What I was submitting, my lord, as per my understanding of the rule, my lord, the clause E2E, it says it dispenses with the, my lord, clause C and D of the rule 2. Now, my lord, thereafter comes the proviso. So proviso says that it should be considered by this the SMC. Now, my lord, after consideration, if the SMC finds it commensurate or appropriate, then, my lord, the SMC will send the applicant.
Yes, that is the medical ground which is to be ascertained.
Yes, but well, at the consideration stage, he was found not to be, my lord, referred to the BMOH or the SMC doctor.
So for that fault, he will suffer.
No, my lord, the role strength is to be considered
No,
before
how you are
sending it.
linking, no, wait, how you are linking the proviso?
My lord, may I read, my lord? 2E, dispensed with the provisions of clause C and D of the sub-rule for applications made on grounds mentioned in rule 4A to D. He has made within that 4A to D. Very well. Now, there comes the first proviso. Provided that while considering such applications, if resultant vacancy of the school in particular subject becomes 0 or not commensurate with the role strength, the SMC shall approach the CSSC. Then, the second
No,
proviso.
not then, Lordship. So the proviso comes into operation after examination and declaring it to be a fit case.
Thereafter,
Thereafter, the proviso says that yes, now if so occasion there is no other teacher, you approach the SC.
But, my lord, that provision comes later. Kindly come to, my lord, F. To F.
F, yes.
Cause to examine the applicant by the doctor of SMC in case of transfer application made on medical grounds.
Yes.
So, my lord, after the provisos are exhausted.
Proviso, how it will be exhausted?
Proviso to the, my lord,
proviso is subject to the condition that the person is found fit for transfer. Medical ground, BMC checked it, all right, it is now 9. Now I will issue NOC. But prior to issuing, but their proviso also gives me a right that now I have no other option to give the NOC. So the resultant vacancy has to be filled up. So I will approach.
The subject condition, in my respect to submission, in that case, my lord, the proviso would have been after this provision, but the proviso has been inserted in the rule after the provision of dispensation of, my lord, rule C and C and D.
What you are meaning to say?
I am
that a medical test, a medical examination is not required. You can keep the matter pending and approach the SCC for the filling up of a vacancy. That is your submission.
As per the rule, my lord,
no. As per is that your submission? Rule F says this is the process of examination.
In case of medical, my lord, in case of medical, he has to be examined by the SMC doctor or, my lord, the BMO.
That is what we are saying.
Yes, but that stage, my lord, comes later. In my respectful submission, that
how
stage.
Can you are saying something absurd. Suppose upon if the application is made and it is kept in the table.
Yes, I got your lordship's point.
So
yes.
the disposal of that application will give
if
the
he
right
is not at
under
all
the
fit
proviso.
for medically fit to be transferred.
If the proviso is to come later, then as per the proviso, the SMC will approach CSSC. He will get the teacher for the resultant vacancy. Correct?
Yes,
that's what you're saying. And then
thereafter he was found.
No. Then, according to you, the medical clause comes in the F,
Yes.
6 to F.
Yes,
And let's say he's found not to be medically
right.
Then what?
Then what happens?
Then the entire exercise would have been futile.
Putting the card before the horse.
Yes, but, my lord, why, my lord, the proviso has been inserted after, my lord, clause E. Thereafter the clause F
So
comes.
let us ascertain
Yes.
if medically he is not successful, then his entire case goes.
Fine.
Yes.
What my learned friend has said, this proviso and all which should come before what should come later, it is subject with deepest respect, it is not correct. 6(2)(e) says dispensed with provision of clause C2D of this subrule for applications made on grounds. Now the first application is to be ascertained by the school whether it is on medical ground or general ground. When it is a general ground, if the PTR people teacher ratio is not correct, school will then and there reject. It is the application stage. Now the application, if it is on medical ground, then comes this medical verification stage. This is the procedure. The word written is application. First, the application has to be sorted out by the school. Yes, medical, you will not be prevented on the ground of pupil-teacher ratio. One, if it is general, you will be rejected on pupil-teacher ratio. This is my first submission. Now, my lord, so far the stand of the school, the Honorable Single Bench has categorically recorded the stand of the school. It has been recorded. The school says that we do not have teacher and it is on medical ground. Two, and thirdly, the same single bench has passed this order on the same ground, absolutely contrary observation. Kindly see. It admits that on 6(2)(c), there will be no withholding of transfer.
Give copies to him first.
Yes.
Don't pick up orders from your pocket and
No, I have
supply
handed
when
over.
the court is hearing the matter.
I have handed over.
You have finished your argument. This is in reply stage, you are saying.
Yes, that's why I'm submitting.
So, Mr. Laidi, there is a process of how you argue.
I have not saying anything.
Yes.
I leave it to your lordship. আর কি বলবো আর।
Why didn't you place it at the first inception?
Your lordship asked him a question.
No, we are
about
asking
finish it.
with the
I was
judge has
about to
taken a
finish.
contrary view.
Yes.
Why didn't you tell it at the first instance?
Could not complete my submission. Your lordship asked him a question, so I did not disturb your lordship. That is why. Kindly see the second page, third paragraph.
Observation, please, Oceans. This considering an application for transfer and distance.
Aspect of a transfer application on general ground,
Right.
distance.
Right.
So there, this is merely an obiter at best. This
Yes.
observation at best is
Yes.
an obiter.
Yes.
Can't be said that
No, I am just showing that the rule has been rightly interpreted in that case, but in my case, the opposite has been. I only appeared in that matter, as a matter of fact. It has been oppositely. That is the law, my lord. That is, it has been done throughout. It is how it is done. Medical ground transfer applications is not withheld.
All right, let them file affidavits. We will consider the point of law. You have not followed what my brother has said. This is the difficulty with the advocates. Have you followed what my brother has said?
It's an obiter.
Then why you are citing this?
Because the law, the same bench has decided the law on the same ground, but in this case, it has been separately decided. That is the
You are
only
not
reason.
accepting that what is being told to you.
Yes, I'm accepting. I'm bound.
No, you
by
are
that.
saying no. I am showing you the view of the judge.
But this way it is very difficult. I leave it to your lordship, my lord. What can I say after this?
You should not say that thing. This is advocacy. You find that the court is in your favor.
Yes.
Let us not disturb the court now. This is the advocacy. It is not the advocacy that let us now confuse the court, put another order at the reply stage. And though you also knew that this is an obiter.
Yes.
Don't you find that?
Yes.
So then why do you place such things?
I cannot submit any further.
You certainly can submit, but you have to learn these things. You're getting a bench which hears you, and you don't know that thing. The present appeal has been preferred.
It is usually paused at the time of dictation of order.
All right, কি বলেছে? Mr. Lyry, however, in his fairness, points out to this court that as his first application dated
Yes. Page 50.
Page 50.
8th of November 2021 was illegally rejected, comma, the appellant submitted the appellant uploaded a further application on identical grounds on 19th April 2022 and subsequent thereto the Utshosri portal was suspended. Yes. Set aside the order. And the school authorities are set aside, set aside, and the respondent numbers and the school authorities being the respondent numbers such and such are directed to consider the appellant's application for
Subsequent
transfer.
application, my lord.
Same ground. Same ground. Actually, same ground.
No, directed to consider the appellant's directed to consider the appellant's application for transfer dated 8th November
19th.
dated 19th April 2020.
My- Great.
In our view, the school authorities, instead of exhausting the procedure prescribed under Rule 62E, would not have denied consideration of the appellant's application for transfer dated 8th November 2020.
No, it should be F. No, it should be F.
Hmm?
2F.
No. To eat
No,
the
no, without exhausting. Without exhausting.
আমাদের মেডিকেল ভেরিফিকেশনটা
2F.
Fine.
Fix 2F.
2F.
In view thereof. এবার ভুলে যাবো তো। In view thereof, the school authorities are directed to consider both the applications for medical, both the application for transfer on medical ground uploaded in the portal on 8th November 2021 and 19th April 2022. ঠিক আছে? And consider and have the appellant examined in terms of Rule 62F, no?
F.
Rule 62F within a period of 6 weeks from date. Within a period of 6 weeks. Needless to observe, in the event upon examination, medical examination, the appellant's case is found to be a fit case, comma, the necessary follow-up steps shall be taken by the school authorities as well as by the state authorities in strict consonance with the provisions of Rule 6 of the transfer rules. Follow-up says 6 weeks বলেছো। With wishes and directions, the appeal and the connected stay application are
My lord, the whole exercise is to be completed within a specific period. Now, whole exercise by the school. Now, the whole exercise, DI will send to the commission. There is no time limit prescribed. Now,
লাস্টটা কি বললে? Found to be a fit case. Then whose functions is the state and the commission?
DI and SSC.
Found to be a fit case, comma, the respondent number, the respondent numbers
Three,
2, 3 and 4.
3 and 4.
2, 3, respondent numbers 2, 3 and 4.
2 has no.
2 doesn't have any.
3 and 4.
DI doesn't have,
No,
DSC
2 is
doesn't have,
commissioner.
Who is Commissioner of School Education?
yes, 2 doesn't have a role.
No.
Does not have a role. Under
Why? Schools representation will be to the, if it is not a fit case, they will have to approach the authority.
no,
No,
if DI
That is one of CSSC. That is one of commission.
Commissioner,
that
2
is
is Commissioner, 3 and 4 within such period.
3
And 4.
no, respondent numbers 3 and 4
আগে কোনো মামলা আছে না?
shall কি follow up বলেছিলেন? Period of, within a period of 6 weeks thereafter.
Grateful to your lordship, extremely grateful. My lord,
Disposed of.
there is an application for condonation of delay. I believe it has been
As we have invited
আগের দিন হয়েছিল তো? আমি
the learned advocate to advance their argument on merits of the matter. How much days delay?
171 days delay.
আচ্ছা একটা লাইন লিখে দেবে, such time bound direction has been issued in consideration of the fact that the appellant's prayer, which was submitted on 8th November 2021, in consideration of the fact that the appellant's within a time bound, within a period of কত বলেছো 6 weeks বলেছো, follow up steps by the respondent number such and such within a period of 6 weeks thereafter with the above observations directed. এটা কি বলতে বলছো? What do you say? Or dispose. Section 5 delay of
171 days. ছোট delay.
we have been at a line. We have been informed that the Uchchosri's portal is still under suspension. তাহলে এটা উপরে দেবে, in view thereof the appellant is directed to submit copies of the applications. Those are not there with you.
So it is not required, my lord. Offline submission is not required because the portal was active and the school has the knowledge and that can be accessed.
That can be accessed. ঠিক আছে, তাহলে-
Temporary suspension will not be a bar in.
Pardon?
Temporary suspension will not be a bar for consideration of my application.
No, we are wanting to know the application which has been uploaded that is still on the site.
Now the site cannot be accessed by the school.
Then how will the
The school, usually what the school does, school asks the candidate that you submit in the pro forma with all your documents, then that can be. That
Yes,
can be
yes.
done.
That is what we have
Yes. Then my lord,
That can be done. Yes.
No, not that case. If not required, then we will not
No,
pass.
they will,
If you find that there will
there
be
is a difficulty, it happens, there is a difficulty, then even it is not given in the court order, but the school asks for the documents and medical documents, kindly,
no, then they will again keep it pending.
yes, that is the difficulty.
তাহলে order dated such and such is set aside করবে. The appellant, আচ্ছা, we have been informed that the Utshosri portal is presently under suspension and in view thereof, the appellant is directed to furnish copies of the pro forma applications for transfer on medical ground along with all medical documents as previously uploaded.
All medical documents, I'll give my recent also, because
All
it is
medical
uploaded.
documents to the school authorities within a period of 2 weeks from date along with a copy of this order. The school authorities thereafter shall consider the same and dispose of within 6 weeks from the date of receipt of such applications. Thereafter, the DI and the school commission shall take follow-up steps within a period of 6 weeks there.
But if the school finds its feet and forward it,
Yes,
Achha,
yes, Nick.
I'm grateful to your lordship, extremely
just
grateful.
my lord, trying that your lordship makes an observation, my lord, that since he has made the second application, my lord, that should be considered. Since he has made the second application, that should be considered and not the previous
We have
one.
explained, Mr.
Yes,
Bandyopadhyay,
yes, your lordship has
first one.
explained, but my lord, it will be, it will become a precedent.
No, we will not, it's the same thing. I'm grateful to your lordship, extremely
Great,
grateful.
great.
My lord, kindly don't text me wrong, my lord. Don't text me wrong, my lord, it was just, I'm grateful to your lordship.
Yes.
Well, I am for the applicant.
For the college. That matter, your lordship.
Which I was asked on the last occasion and today I am answer your lordship that whether this appeal can be maintained at this point of the time when this appellant is admittedly retired from the post, because whatever is the outcome of the appeal, how it is going to affect my rights. My lord, my first answer to this will be the prayer number E of the petition will be the issuance of the deed in the nature of warrant. Yes.
All affidavits were
Are
filed.
exchanged.
So then you file your paper book incorporating everything. We will hear the appeal. There is no such urgency.
My lord, this can be hard one day.
No, we come with a paper book, place the record because
Yes.
there is no urgency, na? Or
Yes,
it is you have retired. We asked you a question, your client is not agreeable, so we have to return a
My
finding.
lord, so that lordship kindly direct for that.
You are for
And for the college, there is a section 5 application.
section 5 আছে.
I'm opposing it.
Get a police law.
No.
I am for the state, but our constitution for the photographers does not survive. The principal, the appellant, she was a contender for the post of principal. But now she herself has retired in 2023. Now in 2025, whether this can be maintained
No,
or not,
one
that
thing,
point.
Mr. Dotto, we asked him, but one thing is, suppose we dismiss the appeal. Suppose we dismiss the appeal, then we will be affirming the finding of the learned single judge.
Yes.
And in that case, he will not even be able to approach the competent forum for damages, if any. Because what we were wanting to say was, or
Moreover, my lord, there
once
is a
we return a finding on that, which he says that we should do. We could have done this that in view of the changed circumstances, these issues need not be re-agitated. However, we would have given him a liberty to approach the appropriate forum for damages, if any.
but the only thing is that, my lord, there is a question of issuance of writ of quo and lordship, so far the issuance of writ of quo is concerned, lordship.
According to petition, Mr.
Yes, my lord.
This was it?
Yes, there was the prayer. Lordship, I have examined the papers and lordship
Then
on
you,
the basis
you
of that.
want to oppose the section 5.
Section 5.
You have exchanged the pleadings on that.
Yes, I have filed my opposition to the section 5 application.
Fix a rate. My explanation was that I am suffering from financial difficulties, and that's why there was a delay. And they are controverting that.
The delay of 590 days, Lordship. So Lordship looks into the section 5 application once, paragraph 4. Your applicant states that due to financial hardship and some personal issue, the applicant failed to file this appeal.
My lord, section 5 application, my lord, paragraph 4, I have explained that your applicant states that due to the financial hardship and some personal issues, the applicant failed to file the memorandum of appeal along with the application for the appropriate order within the stipulated time. The prescribed time limit for filing an intra-court appeal against an order was 30 days from the passing of such order, and hence the last date of file the appeal would have passed on 30th September 2023. The delay count from the last date to file the memorandum of appeal along with an application for appropriate order till the filing of instant applications is 1 year, 7 months, 15 days. My lord, the financial hardship, because my lord, this appellant, lordship, who has not been granted, who has retired dues are not been properly released by the college. There are other litigations she is continuing in this court before court number 18-1.
So you apprise us of the facts. What was the matter about?
My lord, the matter was the petitioner filed this petition. Lordship, kindly may start from the reading the impugned order, my lord. That will give us the entire picture, Lordship. May I read it?
No, when have you retired?
My lord, I retired on 31st December 2020.
31st?
December 2023.
December 2023, you retired from the post of
the assistant teacher of the college. My lord, kindly come to the impugned order once.
Yeah, just give us 2 or 3 facts then. What was your prayer in the writ petition?
My lord, the prayer in the writ petition was to cancel resume the...
Page.
I'm coming, my lord. Writ petition is annexed in the stay application. It starts from page 91. My lord, prayers are in page 90. It starts from page 128. A declaration to issue declaring the respondent number 13 does not possess requisite qualification for being appointed and or for confirming in the post of respondent number 11 and is presently usurping the said office owing to her illegal appointment and as such as liable to be ousted from the same. A declaration to issue that the letter of recommendation being reference number such and such issued in favor of the respondent number 13 recommending her appointment in the post of respondent number 11.
Who is 13?
13 is the
13.
My lord, lordship, then C is the magnanimous for resin withdraw cancel the letter of recommendation. D is the magnanimous. This is specifically for
So when
respondent
did you
number
join?
9.
On the basis of that, you were working in the post of?
I was working as the assistant lecturer of the college. Lordship, I have categorically stated in paragraph number 1, page 98. Teachers representative member, and I have also discharged. Lordship, kindly come to page 98. Recommended that West Bengal Service Commission join the respondent number 8 college as an assistant professor in Bengali on 19th April 1995. Since then, for past 22 years, the petitioner has been working tirelessly for the welfare of respondent number 8 college and aiming for the benefit of the students. Presently, the petitioner is the senior most whole-time teacher of the respondent number 8. So when the writ was filed, he was the senior most teacher of the college. Now, Lordship,
When
prayer
did the
E,
vacancy arose? When did the
Yes.
vacancy arose?
vacancy arose, my lord, in the year, Lordship will find it from paragraph number 5. That is advertisement dated 31st December 2013.
Monetary benefit, your order was August 2023.
Well,
Application filed in, appeal was filed, you retired in December. Then you waited for about 1 year and then filed here.
So I am suffering the financial hardship. Lordship, if your Lordship wants, I can give a supplementary affidavit furnishing all the litigations I'm compelled to pursue presently. Now, Lordship, my case is today.
By supplementary, you cannot improve your stand in the application.
It is only on the financial sufferings which I am suffering. That is the cause.
This
I'm not
backdrop,
going.
why should we allow your application under section 5?
Well, since the delay is caused because of my financial hardships, and Lordship, I can furnish the documents if your Lordship wants by way of filing a
August
file.
2023, you knew the fate of the matter.
I knew, my lord, by the time, Lordship, I had to. That's the reason.
That what is that explanation in your application?
It's in paragraph 4, my lord.
Paragraph of financial, only financial.
That's the only.
Ground simplicity, can we allow your application?
May I come back with a supplementary affidavit furnishing, my lord, the documents regarding the financial hardships which I'm facing, suffering today. That's the.
Now he will say, I will use a reply to that. How pleadings are complete, how can we allow you now?
No, only those documents can be furnished by me. That's all, my lord. Kindly give me that liberty. If your Lordship wants, I cannot improve
Mr.
the
Chatterjee,
cause financial.
We cannot proceed with the chance
But
litigation.
moreover, my lord, another
of
thing.
time.
Moreover, my lord, the presently since there is a prayer for Kumarento, Lordship, for that, Lordship, kindly consider the.
Was any problem? If warranted it is sought for, delay is not an issue. So
I will, Lordship, let me come back, Lordship, to a certain extent. That may be Kumarento.
Mr.
The
You
approach should-
filed your opposition to the section 4.
But we have also not sufficient cause is the precondition. But this sufficient cause is only financial. Now,
Lordship, I have filed an opposition.
about
Lordship, kindly
600
takes my
days
opposition once. I am filing for the college.
Opposition of the
To
college.
opposition to the section 5 application.
What have you said?
Lordship, the order was passed on 30th August 2023. The order impugned. Now, Lordship will kindly see the annexures from page 7 onwards. I have annexed all orders of other proceedings post 30th August 2023 that the petition was contesting all those writ petitions regularly. But in case of this matter, there is financial hardship.
It's admitted.
When the time comes to file an appeal, there is financial hardship. Otherwise, she has been contesting other writ petitions also.
Against the college.
Against the college. Lordship, kindly see page 7. This is an order passed on 19th September 2024, the cause title.
Yes.
19 July 2024. Next, your Lordship will kindly take page 10, 10th January 2025 order. Again, page 11, 14th January 2025 order. Page 12, 20th January 2025. She has been regularly contesting other writ petitions.
That is for her pensionary benefits.
Her pensionary, she would have gotten her pensionary benefit. There again, she did not get it. because she filed a writ petition. Now, there was unauthorized leave on her part. It has been assessed by the college to be 400 something days. Now, 429 days. Now, the DPI, the intervention of, because of the intervention of DPI, pursuant to an order passed by the Honorable Single Bench, DPI passed a report and passed a reasoned order and a report. In that reasoned order, the DPI found the unauthorized leave to be around 279 days and directed us to prepare the service book on the basis of the 279 days leave, unauthorized leave. We wanted to prepare the service book and send it to the treasury so that the pension can be released. But she filed a writ petition seeking that no, the order passed by the DPI is wrong. It should be zero unauthorized leave. So that is hanging.
Another writ petition.
Another writ petition. She is filing one writ petition after another, stalling everything.
Four. There are 4 writ petitions. Why?
She will be filing one after the writ petition. She will She will be stalling everything. She will not allow us to prepare the service book. And now she comes up with the explanation that financial hardship. She herself does not want to get
Always
the
has
petition.
caused the financial hardship for her. That is my difficulty. Initially,
And the
these
entire
number of
provident
days
fund of
for unauthorized
15
leave,
lakhs or 16 lakhs has
as
already been
stated by my
disbursed.
learned friend, is
Mr.
269
Chatterjee,
days.
you satisfy us on the basis of your application that why should we intervene? Finished. Pleadings have been completed. You show us your reply to the stand taken.
Reply কোনটা?
Lordship, in reply, Lordship, I have explained, Lordship, I have given the,
Yes.
in reply, Lordship, kindly come to paragraph 4. With reference to paragraph 4A, 4H of the paragraph 7 and 8 of the affidavit in opposition, I categorically deny allegations, averments, contention therein, which misleading and incorrect. The delay in filing the present appeal was neither deliberate or negligent, but was caused due to the genuine and unavoidable circumstances as explained below. In response to objections, Lordship, 4B, 4G, I reiterate the days of 624 days in preferring the present appeal arose due to the following circumstances. From September 2023 to April 2025, I was undergoing acute financial hardship due to non-receipt of my pension and retirement benefits, which are my only means of subsistence. Despite repeated representations, the said entitlements remained unpaid, rendering me incapable for arranging legal fees and associated expenses required for filing the appeal. Concurrently, I was attending the prolonged illness of requiring continuous medical care and attention. The delay was caused by circumstances beyond my control and not attributable to any malafide intent, dilatory tactics, and negligence. In reply to paragraph 4C and 4E of the affidavit in oppositions, now WPA 20878 of 2024 was filed by me solely for securing my rightful pension, gratuity, and retirement benefits. The filing of this writ itself is a direct reflection of my financial crisis I was enduring. The expenditure involved in filing this writ was unavoidable and a necessary step to ensure survival and meet daily requirements. It does not negate the existence of the financial hardship, rather it substantiates it. B. WPA
He was pursuing for financial hardship. He didn't get his pension.
She didn't
So
get his
without pension, without the dues, that contributes an action.
So in the month of June 2024, the entire provident fund amounting to rupees 23 lakhs was released.
That is his entitlement.
Yes, I'm not on that. I'm just informing Lordship that she had something in her coffer. It's not that she was penniless, she had something. But Section 5, the financial hardship and everything, Lordship will
The present appeal has been preferred, challenging
Red.
Please give your appearances and everything.
Lord, I am for the writ petitioner respondent. Lord, kindly, this is writ petitioner respondent. The issue is decided. Lord, several times adjournment is being praying for this state. Higher pay scale decided by the larger bench, my lord. I completed my physical education post-graduation.
My lord, he was instructed to seek accommodation.
Pardon?
My lord, I was instructed to seek accommodation for the day, my lord.
Your senior, sir.
Lord, London advocate Suman Sengupta is
How
applying.
many times you can?
My lord, the parts of file has misplaced, my lord. We are recreating the same.
Misplaced what? You misplaced your senior.
No, my lord, parts of the file, my lord.
কি বলবো? Records reveal that an adjournment was prayed for on behalf of the appellants.
Right.
Next.
I am for the appellant, my lord.
My lord, I appear for the petitioner respondent, my lord. I am led by Mr. Kolal Basu. My lord, in this matter, I have filed a cross objection, my lord. My lord, but my lord, the returnable date of the cross objection is on 29th.
Pardon?
My lord, in this matter, my lord, I have filed a cross objection.
You are the writ petitioner.
I am the writ petitioner respondent.
Yes, ma'am. 18th of August, this was taken up by your lordship when Mr. Basu expressed his mind to use cross objection.
Oh, I see, yes.
So it has been filed, my lord, on 26th August. It has been filed, my lord. The returnable date is on 29. My lord, I am providing the number.
29th is tomorrow. No copy has been served upon us.
The copy was served through email, my lord, upon the Ministry of Law and Justice.
Has to be deprecated.
My lord, this has been
All voluminous documents are served in email at midnight or sometimes.
He disturbed you midnight, Mr. Chakravarti.
You know, every time I find it is absolutely against the rules.
My lord,
Not
let's
given.
read the lordships.
If your lordship's kindly take it
My
up on Monday.
responsibility, but had I been aware that my lunch senior friend is appearing, I would have personally given handover copy. That is not issue. But in course of the day, I will hand him over.
You've been aware that I will be appearing. My juniors
No,
will appear before the learned single judge. They
Well,
should have been served.
Mr. Jahan is also preferred that a scanned copy should be served upon him. So my
That's for me. That's for me, not for my.
Mr. Chakraborty, my learned senior friend.
Well, I will.
Myself, I am not computer friendly so much.
No, my lord,
We are that period to see the papers. We are not as smart as your senior, na? He's appearing online.
No, my lord, I am sorry. I attended.
He's a serious person with computer. He appears online.
I am technologically challenged, my lord. I survive because of my juniors.
Technologically challenged, and you
Yes.
are online before us, Mr. Basu.
Because I survive because my juniors are competent.
Oh, I see. So you are keeping what a technologically sound.
told-
If your lordship,
Told that Mr. Basu is in Jalpaiguri circuit bench.
Oh, then we are going to dismiss it.
no, my lord, no, my lord, kindly take it.
By
Kindly
the
take it on Monday, my lord. No, my lord, I will. I am not. I am here, my lord. Kindly, my lord. Well, on Monday, my lord, subject to kindly.
This appeal was filed by me.
course of hearing,
One thing, my lord.
Mr. Banerjee learned advocate appearing for the writ petitioner respondent number 1 submits that his client has that the writ petitioner has already filed a cross objection being
COT 135 of 2025.
COT 135 of 2025. Mr. Chakraborty learned additional solicitor, however, submits that no copy of the cross examination has been handed over to him.
Cross objection.
Cross objection, sorry, has been handed over to him.
And
Mr.
pre-application.
My lord, sorry for the interruption, my lord. No hard copy, my lord, because we have soft copy.
connected application is also there.
And the connected application. Yes, what you are saying, Mr. Vasu?
My lord, soft copy has been given, but not the hard copies.
Give the hard copy. Is there any urgency or we keep
Yes,
it
my
up?
lord, I am.
My lord, I cannot. My lord, I am starving, my lord. I am out of employment for the last 2 years.
No, কি বললে? Has not been handed over. Mr. Banerjee submits that he would be handing over hard copies of the hard copies of the cross objection and the connected application to Mr.
Dijodas Chakraborty, advocate on record for us.
to the learned advocate on record of the Union of India in course of this week. By tomorrow, you
Today
will
itself.
তোমাদের সার্ভ করেছে?
within 7 days. Stop. List the present appeal along with the cross objection for further consideration in the daily supplementary list of this court on 15th September.
But one thing, Malord, I have filed this appeal obtaining leave, Malord, without certified copy. Now I have obtained the certified copy. If your lordships,
With that,
I shall file in the department. Good.
yes.
Good.
I mean, it is.
Yes, you are submitting anything.
Below, if your lordships can be allowed to be posted below on 8th of subject to convenience, because below I am out of employment.
You will not be there on 15th.
No, I wouldn't.
Then what
As your lordship, please. All right. my lord. As your lordship.
খেতে পাচ্ছি না কল্লোল বোসকে অ্যাপয়েন্ট করেছি খেতে পাচ্ছি না
Come on 15th we have kept. Yes.
As
my affidavit of service.
Delay.
Yes, my lord, there is a delay. 107 days.
What is the matter?
Lord, kindly take the order impugned, page 113.
This was also medical.
No, this is general.
Distance, bro.
Oh, this was the order you were placing.
Yes.
Yes, what is the
My lord, kindly come to page 107 for once. That was the reason for
I
transfer.
usually not oppose, my lord, in section 5 application. Kindly have a look with that section 5 application. There is no explanation why the delay was called, when my lord application was made.
We can dismiss the appeal also, Mr. Acharya. Just let us ascertain that. Yes.
Would not write, which is not true. Whatever was there, I have written. I could not elaborate in the section 5 application. Whatever was the genuine cause, I have written. I could not elaborate it.
107.
107, my lord, kindly come.
Yes.
The only ground for rejection was single subject teacher, which is no more permissible under 3rd January notification. That was the only scope of my writ petition when that was challenged. Now, my lord, the order impugned, if your lordship takes, the order impugned has gone into...
Your transfer cannot be considered.
Yes, single subject teacher was the only reason that I challenged on the ground that it cannot be because of 3rd January notification, it cannot be. But in the order impugned, my lord, this pupil teacher ratio, it has all been considered. And the prayer was rejected on that ground that it is not in commensurate with the role strength of that. My lord, my respectful and humble submission before lordship, my lord, kindly if your lordship takes 9 AC and 10 AC. 9 AC, that is for single sub.
What was your prayer to be considered in terms of 3rd January?
Yes, 3rd January, that is for single subject teacher. That was...
So, what was your prayer that 3rd January has not been followed?
3rd January has not been followed, and there are already 2 teachers. So therefore, I can...
before 3rd January.
Yes.
Then?
Application was made before 3rd January notification. How
Yes.
3rd January notification?
I tell you,
will come
lordship,
into
why.
the book?
22nd September memorandum, your lordship has in the previous matters considered. It is the predecessor of 3rd January notification that was there. So, my lord, it was also pointed out that I am not a single subject teacher. There are 2 teachers in the school in the subject geography. But the learned single judge has considered that the student teacher ratio is not in commensurate. For which, my lord, I rely upon...
If it is 2, even that the ratio will stand fulfilled.
No. Single subject teacher, whether I was single subject teacher, it was found that I am not a single subject teacher. I'm not a single subject teacher because there are 2 teachers, which has been recorded by the learned single judge.
Where?
Your lordship takes the order impugned, first paragraph. Learned single judge has accepted my contention that I cannot be rejected on single subject teacher ground.
So, if you are not a single subject teacher, in that case, your transfer application on distance ground can be considered.
I only challenge since...
So then what about the 10%?
Yes, I'm coming to that. Only one thing, my lord. I challenge that you have rejected me on the ground of single subject teacher, but I am not a single subject teacher. That was my challenge. Now, my lord, kindly take, it is annexed with my application, my lord. I have annexed all the rules.
Annex what?
The 10 AC. 10 AC I have annexed, my lord. That is at page number 90. 96. 96 is 10 AC. Now, before that, my lord, I would like to show the 62CD for once, because it is the genesis of the application. If your lordship kindly takes page 71 before that, that is rule 62D.
71.
71. Why I'm showing that 62D kindly for consideration, my lord. Consider the total applications from school is not more than 10% of total teacher strength of school, because 62D. Now there was an amendment to the 62D. A notification, I would not say amendment, a notification brought under 62D.
Yes.
Your lordship has seen 62D. My lord, kindly come to page 96 for once. Now, my lord, the first paragraph says, whereas rule 62D of the rules states that the school shall consider the total applications not more than 10% of total teacher strength of school, provided that if sanctioned strength of a school is 5 or less than 5, application of such transfer may be dealt administratively, for which guidelines will be issued by the state government separately. And whereas it is observed that a considerable number of teachers working in a school where sanctioned strength of teacher is 5 or less than 5, and teachers of such school are in dire need of transfer, that due to school level limit of 10% of total strength not able to apply for transfer. As such, the issue has been examined, and in terms of proviso to rule 62D of the rules 15, following guidelines are issued to take care of transfer application of such teacher. Now the similar procedure has been laid down, that is therefore similar procedure, that the alternative teacher has to be brought, and
But
after
this came on 3rd January.
this came on 3rd January.
Your application was of?
My application was previous. My application was at page number, what was the page number? 107. My last application was 3rd September 2021. Now the learned single judge has referred 62D and rejected my prayer. That is why I'm placing this rule, because that has been considered at the time of passing of the impugned order. That is in this second page 114. 62C has been referred to.
No, that is referred to that if it had been a medical transfer, then those two clauses would have
His lordship has referred to 62CD, both. So that is why I'm placing 10 AC, because I was rejected on the ground of 62C and D. While rejecting my prayer, that was referred to. Now 10 AC.
Yes.
Now 10 AC, it makes a provision that even if the student teacher issue is not commensurate as required, but that cannot be a ground for withholding transfer application. Now it has set a level of up to 5, but my situation is not that. I'm above to that. So my case stands at a better footing.
How?
Because it says 10 AC says when it goes down to 5, when it is as low as 5, then also transfer can be allowed. Now my case is better. My students as teacher strength in the school is not 5. It is much higher.
It is observed that a considerable number of teachers working in a school where sanctioned strength of teacher is 5 or less.
Even at that situation, transfer can be allowed. But I stand at a better footing.
So that 10% limit you are crossing? No.
No, 10%.
There are 2 teachers.
Yes.
Then how 10%?
10% of the applied. It is not on the aspect of making 10% applied transfer applications, not on that. What I'm trying to say is that, respectfully, my lord, that the rule has considered that if it goes as low as 5, even then it can be allowed. Then when I am above that, my teacher strength is above that, then that cannot be a reason, because it has been relaxed.
So this teacher strength is pertaining to the group or the entire school?
Entire school. Suppose, my lord, I say rule 5 sub rule 6. Your lordship has seen that says that upon the made applications, 10% will be taken. Suppose, my lord, there are 2 applications filed. and the school has 10 teachers, so one application can be allowed. Suppose my lord 3 applications has been made, 12 teachers are there, so 2 applications can be made. My case is
So
not,
your case is not under 10%.
not 10 plus, but I said because 6.2D was referred, 6.2 has been gone and through an amendment, that is 10 AC. That has not been considered by the learned single judge, where it says even in case if the teacher strength comes down as low as 5, then also transfer can be allowed. But my teacher strength is above 5. 10 assistant
What is your
teachers,
teacher strength
10
in your school?
in my school. 6.2D has gone a change through the amendment. That has not been referred by the learned single judge.
No, but amendment of 6.2D is nothing to do with you. You are above 5. 6.2D
Exactly.
amendment is restricted to 5 or
Absolutely.
less.
I bow down to your lordship. My submission is that even in case
You are
of
trying to draw an analogy saying, well, if 5 can be given, why not
I'm
10?
grateful. I'm
That's
grateful.
what you're
Yes.
trying to say.
That is my submission. Only in respect of 6.2D, because it has been referred to.
Yes, Mr. Mitra.
My lord, before the learned single bench, the report has been filed by the district inspector of schools on in that report.
Where is that report?
The order itself, my lord, reveals 113.
Mr. Who is for the state?
Lord, I am for this.
Do you have that report, Mr.
My lord?
That report do you have?
No, because some other person appeared, my lord, it reflects from the order dated 19th March 2025. If your lordship kindly sees.
What was stated there?
It says, my lord, 10
There are
assistant.
2 assistant teachers, one in higher secondary.
That is correct.
Hmm.
Now, my lord, 10 assistant teacher, my lord, if your lordship kindly internal page 2. The total strength is 1018 number students and PTR is, my lord, 101:1. Now, my lord, 2C, 6.2C, has been quoted, my lord, there. Consider the numbers of subject teachers and roll strength if resultant vacancy of school is particular subject becomes 0 or not commensurate with the roll strength. The authority of SMC shall not forward the application.
Especially when it is made in the distance ground. It's not medical ground.
এটা তো দুজন টিচার রয়েছে, এটা তো হচ্ছে না।
Or not commensurate. Or not commensurate with
Decide what is correct. Decide করুন।
সেইখানে ডিসকাশন
ব্যাপার রয়েছে।
So 6 says if it particular subject it is 0.
Zero, my lord, or not commensurate with the PTR.
Then what will be commensurate?
40:1.
40
That
is
is
to
the Compulsory Education Act. There is a central act. My lord, 40:1 is the ratio should be maintained by the school. It's 101
101:1.
is to 1. So it's very high. That is why, my lord, single judge has proceeded in.
If it was the
And if it is
ground
the
of medical ground,
then it
yes.
will be dispensed with.
Yes.
That is the law.
But suppose his case is not coming under 6.2D.
No.
6.2E, yes.
D. 10% case
No,
is
he is
not
not
his
coming.
case.
That is not the reason that school authority not forwarded.
So school authority has rejected it
PTR.
on 6.2C.
Yes, madam, the record reveals that report filed before the single bench that 101 is
Is to
1
1.
is the PTR, and that's why the school authority not send the name of the petitioner.
But kindly come to the 3rd January
Yes,
22. There is no 6.2C involvement.
No, that is 10%.
6.2C involvement নেই seat আছে হ্যাঁ। So then, Mr. Lairi, how do you come out of that?
First of all, my lord, 6.2D refers to considering strength of teachers in a school.
No, your argument was that 6 to D has been watered down. Now, even if 10%, then also you will consider.
My submission otherwise that even if it is 5 teachers, as low as 5 teachers, then also even below, then also transfer can be allowed. Then also the 10% rule does not come into effect. If that is so, in my school there are 10 teachers, and I'm not even the single subject teacher, and I'm a
Then also 10%, you are taking C and D together.
yes.
But 3rd of January circular does not have 6 to C consideration.
No. But
so if your argument had it been that simpliciter, if it had been on 6 to D, we could have relegated it for consideration. But your case also comes under 6 to C.
6 to C, then comes 6 to D. 6 to D specifies a provision. And my lord, I'm a teacher of Sanskrit. And
no, Mr. Laidi, 6 to D application is not involved there. It is only commensurate or non-commensurate.
Yes.
So it is non-commensurate.
It is not
How
commensurate.
can we help you?
My respectful and humble submission before lordship, only to that extent, when 5 teachers can be considered, then there are 10 number of teachers. So 6 to D has gone and changed
No,
through an
Mr.
amendment.
5 teachers, if the ratio, as Mr. Mitra has pointed out, if the ratio is above 40:1,
right,
then whether 5 or 10, 1, 200 doesn't,
right.
that doesn't matter.
Right.
6 to C has to also be looked into, if not in isolation, but definitely with 6 to D.
Right.
But not overriding 6 to D.
Absolutely.
Then
6
how
to
do
D
you-
does not override 6 to D.
Correct. Then how do you-
Absolutely. I
how do you
understood.
cross
Understood.
6 to C?
My lord, only one thing, in that case, this teacher, even after spending 10 and more years of service, he will never get transfer in his whole service life. One. Secondly,
in case?
In that case, he will never get transfer in his whole service life.
What can
It
be
will
done?
never
That
get
is
transfer.
the rule.
And my lord, only one humble submission.
Page
He's a teacher.
99.
Kindly, please. He's a teacher of Sanskrit. So he is supposed to teach Sanskrit for class 10 and 12. So now the whole student strength has been considered, of the whole school, from Bengali, English, whatever.
But that is the procedure.
That is the procedure. But my lord, he is a subject teacher of Sanskrit. He cannot be, my lord, counted against geography or history, science group.
But that is the rule now. Commensurate with role stream
yes.
is total role stream.
That is a difficulty. But he will never get transferred.
When it is a difficulty, what do we do?
Remove the difficulties by your lordships.
No, we dismiss the matter.
No, your lordship tries to remove the matter.
Kindly,
Remove
my lord,
the
kindly visualize if 10 teachers and the number of classes are 12. A Sanskrit teacher also, my lord, sometimes take classes to geography and history when some other person is not coming. My lord, that is why people teacher ratio is come into play. If there is, it is true, there are Sanskrit teachers read only class 9, but does not mean a class 7 geography cannot be taken by a Sanskrit teacher in a manner if he is not available in a day. That is why people teacher, kindly have a look, page 99.
Yes, kindly see.
This is the amendment. And
He is
you are
already in difficulty, Mr.
as it.
The only thing is that I'm not entitled to take the class if the school says it is voluntary. It is what my learned senior friend is saying.
That
It
is
is
PTR.
voluntary.
That is why PTR
I am not
comes.
bound to take geography class or science class. I am only appointed
No,
for Sanskrit.
Mr. Laidi, how, if you invite us that you consider as my brother told, that even if it is taken in isolation, you are not getting the benefit.
Yes. But my lord, only one thing, that for my subject there are another teacher in school. My leaving
That
the
the
school
code
will not
recorded.
affect. My leaving the school will not affect the teaching.
Record them.
So my lord, in that case he will never, because the appointments are not being done, or even if it's done, it is being challenged. So in that case he will never get transfer for 10-15 years.
No, if
in
the
the same-
people teacher ratio improves, he can
No,
apply.
100 is
There is no
100,
bar.
1 is
There
to
is no
1.
bar.
There has to be various.
What is the sanction strength of teachers in the school? 10.
10.
No, 10 are present.
Sanction
Student.
teachers.
Sanction.
Sanction.
That
The
is
12,
10
well, at least 18 teachers should be there.
Correct. To get that 40:1.
Yes, yes.
আরো বেশি হবে।
No, not only people teachers, there are sanction strength that one this group, one this group, and one honors, one MSc. In that manner, approximately 18 teachers are needed.
Minimum.
I was trying to see if 10 is the sanction strength, then in that school, no teacher who gets in once can ever leave on transfer.
Can never leave.
No, it is not there. If some other
He
teachers
can never
come,
leave.
it is improved.
No. If it is 10 is the sanction strength,
No, it's
but 10 is not the sanction.
not the
strength.
sanction. But for Sanskrit, there are only 2 sanction posts, and those are filled up. And he can never leave, ever. He has joined in the school on 2013. 12 years he has passed, and he can never come out of, even if there is a provision of transfer. He can never come out of the school.
But how can we detect beyond the rules?
Referring, if your lordship can kindly refer to that analogy of 62D 10AC.
But 62D is not applicable in your case.
But kindly appreciates, even if 5, then more than one application is being considered under 62D 10AC. But then why not in my case, if I may pose this question to myself?
Because you are stuck in 62C.
I'm stuck in 62C. That is the answer. Yes. But at the same time, this is also the analogy that 62D are allowing. And that your lordship may accept, may not accept. That is my humble submission with your lordship. That he will never be able to get transferred.
May I make one submission?
What?
And on page 99, your lordship, kindly have a look. That is clearly stated. Those are 2 different things.
99.
That is an amendment. Provided an application for general enterprise shall not be entertained by the concerned school authority if pupil teacher ratio of the school falls deficient as per the norms laid down in the Right to Children and to Free Compulsory Education Act 2009. That is a central act.
And that ratio is given there.
Ratio is given.
Yes.
40:1. So, my lord, it comes later on. If the single teacher's point are taken only, then it's all right. But the report reveals, my lord, it's a 101 is to 1. That is why, my lord, it has not been. That is why the learned single judge proceeded on the 62C.
In 7 days.
What the status will be?
9, 10.
9, my lord, I am appearing for the commission. It's not similar. It's a wheeling. That wheeling.
Sir?
This is transfer matter. What wheeling has been incorporated.
So we have passed the, oh, willing.
Wheeling what? My lord, petitioner wants that wheeling should be
We can
omitted.
pass the order.
My lord, Mr. Lahidi is not here.
Junior is.
I ordered 10 I am there.
I think 10 is also similar matter. I'm for the commission, but only one difficulty is there is a delay of 336 days, which I will oppose.
আমি পরেরটা করে নিই দাদা।
The delay I will oppose because
339 days delay, my lord. 339 days.
তোমারও delay আছে।
আমারটাই কত আছে দাদা? তুমি 9 নেই কি?
Whether
9
না 10 তে বলছি।
candidates opted for, whether they are still available or not due to the
Which candidates opted for?
the schools where they have opted for transfer, whether that school is still available, because for 336 days the candidate.
39.
No, we will not be doing so. It will be rejected in that case. We have not said that consider it, treating it to be of that stage. সেটা বলিনি।
Item 9 and 10 same identity.
না 9
my lord. My lord, 40 code number 14 lordship. 14.
So the 8 টা হলো তো।
Yes, lord.
So 9 and 10 we keep it to be mentioned tomorrow.
Yes.
In 9 or 10 because it is covered by the order. Still
9 is wheeling what? 10 I don't know. 10 is
Yes,
the-
10 Dr.
same.
Patro says that it is willing, but
Willing
he
part.
says that I will oppose the
As you lord.
Section 5.
Section 5.
the 9.
ও আচ্ছা আমার ডিলেটা কত wheeling না কত?
You are not opposing section 5. Yes, tell us item number 8 is Mr. You are there?
8 my lord, your lordship has taken up now already. 8 order হয়েছে।
এইটা এবার 9 নম্বর।
নয়।
আচ্ছা তো দেখো ইয়েকে in this case is there any communication of DI that I have sought for willing teacher?
It is the only word wheeling, my lord, petitioner one. Kindly have a look, page 97.
এই যে কালকে না পরশু দিনকে একটা Yes, sir, we are passing that order.
Lordship, kindly make a note today, lordship.
হ্যাঁ
My senior is not here, lordship.
দুটোর সময় তো আমাদের তোমার সাথে কালকে এই তাহলে এই দুটোকে কালকে ওই অ্যাপ্লিকেশন হেডের টপে দিয়ে দিও টুমরো at 10:30
Yes, lordship.
না টু বি মেনশন না কালকে কোনো টু বি মেনশন আছে কালকে কোনো টু বি মেনশন দেখে নাও না তাহলে এটা 1-2 নম্বর থাকবে
সকালবেলা করো তাহলে সুবিধা হবে।
টুমরো ইট উইল বি at the top ABS কর্পোরেট
আগে হয়ে যাবে। ও আচ্ছা তোমার একটা সেটা অর্ডার করো তুমি করো ফোন
যদি তাই দেখো তাহলে টু বি মেনশন
আমি না থাকতে পারি তুমি আমার এটা
we have kept 2 matters tomorrow. He is not sure. If those 2 matters are there, we will keep these 2 matters as to be mentioned. And if there is no other matter, it will be the first one.
দেখে
Record put the
That is for your lordships to
today an adjournment has been prayed for on
এই জন্য ফ্রাইডে করে থার্সডে করে থার্সডে হয়ে গেল সিনিয়র
My lord,
My lord, may I
may I
have
be
it?
permitted to mention, my lord, last sitting date, I have mentioned 4 matters, my lord, that contempt matters, my lord. This is the urgency is that, my lord, on 12th December 2024, the result was published. My lord, they are losing, my lord, and that if within one,
Using what?
they are losing their seniority, my lord. And
Meaning-
moreover, my lord, moreover, if the 1 year completed from the date of my lord, medical examination,
You
again
contempt.
they will face
You contempt.
no, my lord,
Ah.
after service, after service.
After service?
After service. My lord, 32, 31, 32, 35, 36, 40, 41 and 43. My lord, your lordship's last occasion, my lord, asked me to remind on next
Bring
sitting.
your other side. Bring your
My
other
lord, my lord, I don't know, my lord, Mr. Ramchandra Agarwal is appearing, usually appearing all those matter, my lord. My lord, may I make a call and come back, my lord? If not, my lord, I am not taking, this is your lordship to take up this matter today itself. My lord, kindly takes up on to after under the heading to be mentioned next sitting
This is
date. my lord.
31 to
31, 32, 35, 36, 40, 41,
33 is different.
33 is different.
Sir?
35, 36,
Asking for 3 months.
40, 41 and 43. My lord, can it be taken up to be mentioned on next sitting date?
40,
That will be
41
better,
and
my lord.
40?
Otherwise, 43, 41 and 43.
How can we accommodate this? See if you can get him. See if you can get him come at the time of rising. Yes.
My lord,
But-
may I have your lordship's leave to mention item number 50 of your lordship's list, your lordship. Lordship, for the extension of interim order, my lord, I couldn't inform my other side, your lordship. If it could be,
Bring your other side. Bring
lordship,
your other side.
lordship,
and
lordship.
write.
Grateful.
Yes.
Start.
Well, sir. No, we would be making a request. If you can conclude both of you by, because again there is a 3:30. If you can conclude, Mr. Basu, then we will proceed. Or if you say that it cannot be concluded, then we keep it after the vacation.
That may be tolerated, but don't release it.
No, release, my lord. No releasing.
No, we wanted to hear you, not on that day. You were not present. We specially fixed the matter on that day for you.
Sure. And fixed on Thursday because usually Friday 3:32 we have.
Again 3:30.
We have some, before vacation has to be completed. na?
Some backlogs.
Vacation একটা থার্সডে করে 13 the Thursday. We can continue if so happens. We will continue till the next day.
Not take much time. Whatever he has submitted up till now, I have prepared the
If you
replies.
can finish, Mr. Basu, we will take it up. No problem with us.
I don't know how long he will take.
No,
I-
13th
I am also
November.
prepared to note up till what he has said. But if he adds something more point, then I have to incorporate that.
That we cannot stop him, Mr. Basu.
No, we are.
13th November, 2 p.m. Yes.
Well, the next two matters also on the same day.
Mr. Mitro, why you are waiting? Go to another court. In this matter, whatever we delivered, we will deliver.
No,
We also are being embarrassed. Now we are keeping the matter fixed.
Next two matters on the same day, my lord.
Yes, it has to be because the same
The
point.
same
I
point.
want to share also.
So বৃহস্পতিবার যে ডেটটা দিলাম সেদিনকে শুধু এই তিনটে ম্যাটারই বলবো। We are keeping it at on that day specially fixed for your matter.
Lordship.
Mr. Gali, are you appearing in the remaining two also?
Yes,
Remaining
my
two
lord,
matters-
he has been given, I have heard.
You have been given?
Last week I have been given the,
So very good, then you get yourself ready.
I'll have to get myself prepared with those two matters.
And we would request you to conclude on that day so that we can, at least we can deliver our judgment. Na? The
Another
matter
thing,
is
may I
being
request? Another thing, may I request to Mr. Galib through my lord? If he is preparing a note of his submission, and handed over to me, I can make ready on that day and reply on the same day.
See, Mr. Gali, if you can assist it, we
On this
cannot-
matter, Lakshadweep.
Because up till now, what I have said, I have prepared my notes and ready.
শোনো ওই বৃহস্পতিবার শুধু ওই তিনটে ম্যাটার লিস্টে দিয়ে দেবো। ইয়েস,
কি বলবে আবার?
সাপ্লিমেন্টারি তো পাবো।
না না, ও একসঙ্গে।
it is item numbers 3, 4 and 5.
43, 44 and 45, 44, 45, 46.
This is the 44th, the item number 44.
ঠিক আছে, 44, 45, 46. And where is that KMDA matter? Where is she? ও, আসছে। তাহলে এই অম্লান, এই তিনটে দেবে না, তার সাথে
অর্ডার কিছু পাস হয়নি? খুব
বলে
অন্যায় ব্যাপার,
অর্ডারটা দেওয়া
খুব অন্যায় হয়। Injustice to lawyers, not to litigants. Injustice to lawyers.
You still require Mr. Basu?
If I don't get, they will not get.
Oh,
We
you're
request
so
through you.
concerned about it.
Certainly. It is unknown to my lord. I'm concerned with the lawyers.
We will give appropriate reply to you.
No problem. Let them get.
তিনটে একসাথে অর্ডার হয়ে রয়েছে তো?
তোমার এটা জিনিসটা সুবিধা হবে
আমার
তারপর।
কিছু লাগবে না, একসঙ্গে করে দিবি, আমার দেখা আছে। ওরা বলবে আর কিছু করতে হবে। এইটা addition করবে, ওর সঙ্গে লাগে।
We have heard, Mr. We have
Wait for time only for this meeting.
records.
To bring my lord all the records and
Yes.
the before and other things, my
It
lord.
has not
But
come.
up till now, my lord, the officer yesterday they told me they must come with the, but up till now they did not turn up, my lord. I am very sorry, my lord. I may not want to take
So, Mr. Dev, tomorrow we will be again sitting.
then, my lord.
So we are keeping it tomorrow. হ্যাঁ, কালকে পার্থর সাথে আছে। কার সাথে? তুমি কবে দেবে? Tomorrow it won't be. We are not fixing the time because if it would be possible.
May I help your lordship? My lord, the P form, which was required to look into, that is very much in the writ petition.
Yes, we have seen that.
And that is very much in the writ petition. And kindly see
Mr. Roy, we wanted to see the handwriting.
my lord, and kindly see the certified copy of the order, my lord. They have given that the plot of land is.
So
a reclaimed
Mr. Day has not, Mr. Day had not, he said that I will go through the records and come and tell the court. If it is there, I will not say anything.
Yes, my lord. I have.
That is what he said.
For that is, my lord, I must take
That
5 minutes.
Let Mr. Day see the record and then it can be solved. No?
Kindly keep it tomorrow, my lord. I will show the documents which I have.
Tomorrow we cannot sit because tomorrow we have a fixed matter in the other ways. We are keeping it on 12th. It will be the first matter. Mr. Day,
Yes, my lord.
come on that day.
If I have seen that there is, my lord, in favor of my learned friend, my lord, I may not want to.
Please,
Yes,
please
my
tell us on
Yes,
that
my
day.
lord. Only 5 minutes I must take on the previous occasion, my
19
lord.
years I am suffering. They should be, my lord.
Wait for 19 days more. Yes, next.
As your lordship pleases, on 13th, my lord.
12th.
12th.
My lord, in the
12th is a Friday.
in the same position.
It is to be mentioned already. But 12th, if we decide, if it can be said that we can sit from the morning, so we
Yes,
are
my
not
lord, I must
fixing the
come.
time.
Yes, my lord.
So we will publish our list prior to that.
Yes, my lord. One day.
Yes.
My lord, order may be passed otherwise. Let them.
Mr. Dale and its additional government leader submits that the original records
So I appear on behalf of so kindly peruse the order dated 3rd of March passed by this Honorable Bench. Kindly peruse the order dated 3rd of March. Hearing was concluded. It was kept only for the purpose of passing of order. If your lordship so desire, you can come back with the written notes. Order dated 3rd of March.
3rd of March
2025.
Yes. Yes, Mr. Hussain, kindly.
We have, yes, my lord, my land is correct, my lord, to that effect, that hearing was concluded, hearing was made, and it was heard in details
No,
by.
you have to remind us, now. We don't exactly
Yes.
remember the facts
But
again.
only matter of fact.
Acha, show us the ordered impute. Paper book is there.
Yes.
No, impute order, my lord, page 471.
471, second volume.
Second volume.
Page 471. Start from page 471. No, 475.
475 is the ordering portion.
Order starts from page 475.
Yes. A writ petition was dismissed.
No, writ petition was allowed.
Which challenge there?
May I just, for short matter, the issue was involved for fixation of pay at par. This is regional rural bank. The writ petitioners, they were the employee of regional rural bank, Mallabhum Gramin Bank, which has now been renamed as Bongio Gramin Vikas Bank. Now, they, considering the pay parity between the regional rural bank at par with the sponsor bank, a committee was constituted in terms of the order passed by the National Industrial Tribunal. That committee recommended that this should be the pay fixation of pay for the regional rural bank. Based upon that fixation, the bank implemented our pay scale. Subsequently, bank, they realized that the fixation that was done by the committee, that was wrong. So they voluntarily intend to withdraw the benefit, which they cannot. The Honorable Division.
Amount which was paid to you.
Yes.
Excess amount.
According to them,
it
that
was
was
not part of the
excess.
bank.
We are coming back. So what did the, so you challenged the recovery?
Yes.
It was stayed.
Yes.
Now you have retired.
Most of them have retired.
How many persons are there?
Lordship, here only 5 they filed apart from the association. The writ petitioners were 5 and the association.
Very good. Now what this recovery which they attempted to make was challenged.
Yes.
Then what did the court say?
Lordship, they ultimately, by virtue of order, they wanted to recover. That order has been set aside.
Which order has been set by which they wanted
to recover the amount.
Achha, on what ground it was?
Now the Honorable Single Judge said that in terms of the National Industrial Tribunal's order, only the bank, if they found any discrepancy, Lordship, kindly come to page. This is that particular order. It starts from page 46, volume 1.
475.
That was the order of the Honorable Single Judge. Relying upon that particular order, by virtue of which our pay was fixed at par with the Lordship, that order is at page. It starts from page 46.
No, you show us the reasoning of the judge now. Finish.
Yes.
Page 475.
475, it starts from page 475.
Yes.
One to 5 of the writ petitioners, they were the officers, and 6, 7 is
Withdrawal of circular of 21st October
2005.
What is the page number of that?
Lordship, that page 137.
Yes. Page 137. That is paper
Volume 1.
Yes, 137.
Implementation of revised pay scale and payment of increased salary thereof to the officers and workmen of Mallabhum Gramin Bank in terms of Government of India's Ministry of Finance order
Lordship, the Honorable Single Judge held that since you have implemented the pay scale based upon this particular order of the Finance Department, you cannot at your own say that this fixation was wrong. So I will rectify it.
Quickly place the order.
Yes.
Then we can ask Mr. Hussain to. Mandamus was sought for challenging this 21st October.
Yes.
Then what happened? Come on, go on reading.
Now this payment and increased salary thereof to the officers, workmen in terms of Government of India Ministry of Finance order dated 6 October 2005.
Yes.
Thereafter the submission has been recorded.
No. Here on the subject implemented to the officers and workmen in terms of the 6th October 2005 Finance Department memo is at which page?
The Finance Department memo, that is at page
6th October 2005, page
Yes.
136. Yes, 6th October to page 106.
136.
Then what happened? Place, what is your contention? You were the writ petitioners.
Yes.
Yes.
Lordship, prior to that, based upon which the Honorable Single Judge allowed my writ petition, Lordship, kindly for a moment.
We will go, rapidly go through this portion. Mr. Basu submitted by the circular fitment given to officers
To the regional rural banks in effecting parity with the officers of the sponsor bank was sought to be undone. Referring to the affidavit in opposition affirmed by the respondent number 6 on behalf of the respondent number 4 and 5, Mr. Basu submitted that it was the case of the respondent number 5 that in the matter of two petitions filed before the Honorable Supreme Court of India, the order was made on 1st September 1987 to the effect that central government shall constitute a national industrial tribunal and refer salary structure of regional rural bank employees who are demanding parity with employees of their sponsor bank on the principle of equal pay for equal work. To it, pursuant to the said order, the Government of India by its notification dated so and so appointed the National Industrial Tribunal and referred the dispute to it. The NIT pronounced its award on so and so, but as regard to equation of post and fixation of pay, allowance and other benefit, the said tribunal directed that was a matter which had to be decided by the central government in consultation with such authorities as it may consider necessary. Following such direction, the said award could not be implemented, so government constituted equation committee NIT cell to make appropriate recommendation. The equation committee cell arrived at decision which were reported on so and so. Such decision.
My pages are missing. 477.
Page 477.
477 at the. Yes. Four 77. Yes.
Got the equation committee NIT cell arrived at decision which were reported on 16th March 1991. Such decisions also covered the cases of employees, officers promoted after appointed date, that is 1st September 1987. The date of order made by the Honorable Supreme Court as aforesaid. The said decision were reconsidered by the equation committee on 30th April 1993. It is the petitioner's case that on receipt of the Government of India's order dated 22nd February 1991, instruction implementation of the award of NIT and pursuant to clarifications dated so and so made by the equation committee, the said promotee employees fixation of pay in sponsor bank pay scale of clerical cadre as on appointed date was made. The respondent number 4 and 5 having duly implemented the same in the year 2005 sought to illegally undone the same. The petitioner's grievance is that such fitment was sought to be undone by the impugned circular.
Your issue was referred, central government said that form a
Equation committee, first NIT,
tribunal passed an award.
Tribunal passed an award so far as the fixation of pay and other structure is concerned. For that, tribunal said it is for the central government to fix a committee based upon that recommendation made in the award. The central government in consultation with the Ministry of Finance, they formed a committee. The committee made recommendation or regarding fixation of pay.
Hmm.
The respondent bank, the Grameen Bank,
Implemented it.
they implemented it.
Very-
All through we have enjoyed. All on a sudden,
87.
yes. All on a sudden in 2005, they wanted to undo it.
Very good. Now, then Mr. Basu, relying on the government order of 22nd February, drew attention to clauses such and such.
Treatment was sought to be undone by the impugned circular, which was without jurisdiction or authority and liable to be set aside, should be quashed. Our contention was that since the fixation has been made,
Implemented, you cannot
yes,
recover.
at your own you cannot undo it. Unless the equation committee, they said that no, our fixation was wrong. Now, if your lordship for once kindly come to the order of the, by virtue of which our fixation was made. Lordship,
No,
that
we will
is,
come later. Please show us the reasoning of the judge.
yes. That was the submission.
That was what was their submission place?
Their submission that
Come, which page?
478.
Second paragraph.
478.
Second paragraph. Starts from second paragraph.
Mr. Raut, learned advocate, appeared on behalf of the restaurant number 427 and submitted the impugned circular was issued in rectification of mistake made earlier and thereby no legal right of the petitioner could have been infringed. The government of India by its order dated so and so had accepted the order of NIT dated April 30, 1990 and the recommendations of the equation committee dated 16 January 1991. The order provided the procedure regarding fitment into new scales of pay of employees, officers of regional rural bank in the corresponding post of comparable table under sponsor bank as on 1st September 1987.
Very good. Then that was the quoted portion.
Yes.
Now kindly come to 479. The respondent numbers 4 and 5
had stated in their affidavit inter alia as follows. The bank accepted recommendation of
bank means the Grameen Bank.
Yes, Mallabhum Grameen Bank, now Bongio Grameen
Accepted the recommendation of NIT
cell and issued fitment slip to each and every employee. At that time of fitment of all the sponsor, senior clerk come cashier promoted to field supervisor as on second, as on so and so.
2nd March 1988.
As on 16th March.
After the appointed date, 1st September 1987 was rightly made at initial stage, that is basic pay of so and so as on date of their promotion. A copy of the fitment slip of the petitioner is annexed hereto and marked as so and so.
Then respondent number 5
had issued an order dated 18 October 2005, relevant portion of which is reproduced below.
Who is 5? Mallabhum.
Yes.
Huh? Yes.
Grameen Bank, Mallabhum Grameen Bank.
The 18th October memo is at which page?
18th October memo is at page.
Page 137 is the order of 21st October.
October.
That has not been annexed. 18th October.
So 18th October they issued an order. Very good. What did they say in that?
Possibly 18th October memo is not there.
That
but
is not. That has not.
21st October by virtue of which they wanted to adjourn, that is annexed at page 137.
That we have seen.
Yes.
Now this 18th October.
18th October, it has been.
Anomaly inside. Now next paragraph. It is thereafter the impugned circular providing
guidelines in implementation of revised pay structure, including payment of increased salary of officers with effect from 1st November 2002 at par with sponsor bank was issued.
Yes, now read this. Clause 8 Roman 2.
Excess salary drawn for wrong computation, non-adherence to instruction of fitment slip would be recovered with commercial rate of interest, and concerned DDO shall also be held personally liable for such excess payment. This does not preclude the management to take any other action against the erring officer employees as may deem fit.
Just a moment. Now on the basis of the pay division implemented, you got the enhanced benefits.
Yes.
Now this recovery is pertaining to the excess amount.
according to the bank, they have wrongly given excess amount. But our contention is that the fixation has made as per recommendation of the equation committee.
All right. Yes, then the court
The
finds.
bank said, no, it was our mistake. It was,
That must have been
the
pointed.
court finds that the case of the respondent bank to be that the recommendation of fitment formula by the equation committee as decided in their meeting dated was correct. The said respondent, however, contended the clarification dated so and so of the equation committee on reconsideration of their earlier recommendation for fitment of those promoting field supervisor resulted in issuance of wrong recommendation of their fitment at second, third, and fourth stage of officer junior manager 1 scale instead of initial stage of junior officer management 1 scale. This anomaly was detected and impugned circular issued in rectification. The facts are the government of India by its order dated so and so had accepted inter alia recommendation of the equation committee dated so and so. Subsequent thereto, NABARD by its letter dated to the sponsor and regional rural bank in the matter of implementation of NIT award read with the said recommendation of the equation committee as instructed by the said government of India order dated so and so. Had addressed certain operational problem which had cropped up as extraneous pay scale allowances, etc. The regional rural bank employees were sought to be converted into near homogeneous pay scale allowance, etc. of their sponsor bank. It does not appear by that letter of government of India through NABARD had required the equation committee to reconsider its recommendation dated so and so. Regarding fitment, the respondent number 4 and 5 have stated in their affidavit and annexed copies of document to show the said regional rural bank had accepted the recommendation dated so and so of the equation committee in issuing fitment slip to the petitioners as annexed thereto and marked annexure C1. The said respondent further stated in their affidavit revised fitment slip of the petitioners were issued, copies of which are annexed to the said affidavit. It appears from the revised fitment slip dated so and so, the same do not refer or were pursuant to any recommendation dated 30th April 1993 made by the equation committee on reconsideration as alleged by the said respondent NABARD's letter dated so and so as referred to and the basis of issuance of such revised fitment slip. In the circumstances, the said regional rural bank in altering the fitment by issuance of the impugned circular purportedly in rectification of mistake made cannot be said to have had authority to do so. It is not the case of the said regional rural bank that there was an error made by it in implementing the fitment formula as would appear from the revised fitment slip issued by it. It is not the case of the respondent bank that they wrongly issued the fitment slip. On the contrary, they said that the recommendation was wrongly made. Our contention was that they do not have authority or jurisdiction to say if they want any clarification, they ought to have approached the central government through the Ministry of Finance. That is the circular said.
Which circular?
Lordship, that I wanted to show your Lordship.
That's very good. Now,
in the circumstances, the regional rural bank altering. On the contrary, it is their positive case. Anomalies had been
very good.
detected.
We got it. You give us the relevant dates.
Lordship.
5th of
Now, Lordship, so far as the jurisdiction is concerned, whether the respondent bank, they can at their own.
We understood. Let us hear Mr. Hossain. What is his stand?
Lordship,
He
kindly,
has said-
once kindly come to that document.
Which document?
Lordship, the authority, it is a lack of jurisdiction. Lordship, kindly come to page 46 at volume 1. It starts from page 46. Ministry of Finance, Department of Economic Affairs, Banking Division, 22nd February 1991. Lordship, kindly come to page 57, the concluding part of this particular notification.
What is page 46?
Lordship, this is the fitment formula based on which the bank has fixed our.
This is after the award and
Yes,
inquiry
yes, yes.
and the scrutiny
Yes.
committee report.
Yes.
NABARD issued the circular.
Yes, yes. Lordship,
This was
kindly come.
NABARD circular.
Yes, kindly come to page 57.
Yes,
Serial number 16.
yes.
Lordship, might be the typographical. It should be any interpretation or clarification. It should be read like this. Or the equation and fitment should be obtained from Ministry of Finance, Banking Division, Government of India, New Delhi through NABARD. So in the event the respondent bank, while implementing
Any interpretation
or clarification,
Interpolation.
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 interpretation.
Flat installation.
In any interpretation or clarification.
Clarification. It should be read like this because it does not make any sense. Whatever it was a cyclostyle made, so might be the typographical error.
So you don't have don't have that circular?
Yes, that was annexed with my read petition, but while the filing the.
So the interpretation for any interpretation of such fitment, you can apply through NABARD.
Yes, it's for me also, for the bank also. They cannot at their own say that the recommendation was wrong, so we want to either withdraw it or to add something in the fitment.
Very good. Now kindly show us from the impugned order of 21st October 2005.
Yes.
What is their ground? We can. That is at page 137.
137. Implementation of revised pay scale. This was issued on the basis of 6 October circular, which is at page 136 of the paper book. The bank, in terms of order number so and so, the previous page order, Government of India, Ministry of Finance, Economic Affairs.
6th October. 6th October is
that is at page 136.
That is a communication to chairman of
all regional rural banks by the Ministry of Finance, Department of Economic Affairs, Banking Division. The bank, in terms of order number so and so, Government of India, Ministry of Finance, Economic Affairs Department has decided to implement the revised pay scale, including payment of increased salary to the officers and workmen employees of the bank. The guidelines for implementation of the revised pay structure, including payment of increased salary as per 8 bipartite settlement for workmen and corresponding salary revision for officers with effect from 1st November 2002.
No, we understand. You please give us the sequence now. When was the award passed?
Proceed. The award passed. Everything.
Where is the central government order directing constitution of a tribunal? March 1993.
The order of the Supreme Court was 1st September 1987 because that is the 1st September 1987. That is the order passed by the Honorable Supreme Court.
Where is that?
Because that will appear from the order of the Honorable Single Judge.
No, that is not annexed here.
Because page 476.
Yes, order of Supreme Court was
1st September 1987.
1st September 1987. Which,
the Honorable Supreme Court.
Yeah, no. Why that SLP was filed?
The writ petitions SLP was preferred for removing the anomalies of pay in the same scale of pay between the employees of regional rural bank and the sponsor bank, because they are discharging same duties. The employees of regional rural bank.
All right, that the Supreme Court said that you constitute a tribunal. On the basis of Supreme Court's order,
the National Industrial Tribunal was constituted. The
now, constituted tribunal passed an award.
The 26th November 1987, Government of India constituted the tribunal.
26th
November 1987. Tribunal was constituted.
Very good.
Now the tribunal passed his award on 30th April 1990.
30th April 1990. Award.
Award was passed by the tribunal.
Very good.
The tribunal said that regarding the fixation of pay scale, you must appoint a particular committee for regarding removal of anomalies. Based upon this award, the equation committee was formed.
Equation committee for
Equation committee,
5th October,
the
1990.
equation committee arrived at decision which was reported on 16th March 1991.
on 16th
March 1991.
that you showed us that clause. No,
Look,
that
that
was
is
never.
Government of India order 22nd February
Now,
1991.
after a decision was 16th of March 1991 that they should get the same scale.
Yes.
Now that this was implemented when?
Lordship, implementation of NIE orders pursuant to clarification 30th April 1993.
That is the Mollabhum, this rural bank.
Mollabhum Gramin Bank. At that point of time, it was Mollabhum Gramin Bank.
So that was implemented on 30th April 1993.
Clarification was made on 30th April 1993.
Clarification.
Yes.
By the bank.
And it was implemented. Since then, the writ petitioners' employees, they are enjoying that.
We understand what clarification was sought for. You are saying clarification?
No, Lordship, it is the committee, equation committee, they made recommendation. Lordship, it should be a recommendation or instead of clarification. They made the recommendation. And that was implemented by the bank. And all through they were enjoying. All on a sudden in 2005, they tried to undo the benefit which we have enjoyed this long period. And it was said that it will be recovered along with commercial rate of interest.
Now kindly come to page 155.
Lordship.
You yourself undertook.
Now, Lordship, I want to distinguish. This is not an undertaking.
Submitted,
Yes.
That was the submission. Lordship, kindly go through the document. Whether it cannot be said that it is a undertaking.
When did you retire? When did you people retire?
Lordship, on various dates, not a single.
So on the date of order for recovery, you were there.
Yes, yes, I was there in service.
So you
Lordship, kindly come to page 160. Which
no, first come to 155.
Yes.
His argument was that you yourself, you have.
No, Lordship, kindly see the
155
document.
of
What
what?
is the
155
document?
to 164. The entire document will show that they gave an undertaking.
Page
155 to 164.
Kindly consider page 155. This is issued by the.
Just hold. This was one ground of yours.
Lordship.
What is the other, any other ground you are arguing?
Only ground is, my lord, that there was some error in computing the, my lord, award, and wrong increment was given on the basis of that fitment. So, my lord, subsequently,
Then why didn't you withdraw that?
because one of the excess salary was paid due to
You
some.
implemented it. You implemented it on 30th of April 1993.
Kindly see, my lord, page 155. They gave an until in
So we are coming to, let us
2005.
understand. Let us understand. 30th of April 1993, you implemented.
No, 30th April 1990, NEET passed the award. 30th April, the NEET passed that order.
No, no,
Award,
NEET
yes.
passed the award on 30th April 1990.
1990, NIT passed the order.
No, no, now you implemented on 30th of April 1993.
Kindly, my lord, once I am drawing your lordship attention, can you page
Sir,
155.
According to
They
you,
were given, lordship.
come to you. Please tell us, according to you, when did you implement?
2005, page 155. It will clear from this, but effect was given.
155 is the undertaking you are showing.
Yes, but that will be clear from that, my lord, that on the basis of that undertaking they took, and it will show that from 19, the earlier effect.
Implementation was in 1993.
No,
with effect from 1993.
with effect from 1993, but it was given in 2005.
Acha, with effect from 1993. Implemented in 2005.
Lordship, 2005.
Very good. You implemented, where is the order of implementation, Mr. Hussain?
Well, my lord, after getting the same, my lord, we implemented. It will clear from the, my lord, page 155 also. I mean, once
Okay,
again, my
then read page 155.
lordship.
Please place. Name of officer such and such,
Such and such.
HRA, cost of, এ তো construction of house, এ তো loan নিয়েছে।
Your lordship, there is an indication.
The right hand side column, it is horizontally stated, this fitment is subject to change in case of any discrepancy detected later on.
Lordship. Later on, it was detected. We issued notice that yes, excess salary was.
You issued notice on this October 2005.
Yes, after so there was no such delay. October 2005, it was given effect. Soon thereafter, when it was detected, we should notice and we.
Where is that notice you issued? That is the circular you issued which was challenged. But Mr. Hussain, we do not find any undertaking given by the person. Do you find any line to that effect?
No, not to that effect. They're undertaking
So you
specific.
are relying upon this clause that
Yes.
rectification can be made.
Can be made.
Very
We rectified the same. That was the error. So we rectified the same in the
So
2005.
you must have said in your withdrawal memo what was the rectification required. When NABARD has said that you cannot rectify, you can apply for rectification to the appropriate government through us. That is NABARD.
NABARD.
That is the clause.
No, but in case of fitment, if there is any discrepancy in case of fitment, only then the NABARD consent is required. But if any increment was given on the basis of the, my lord, the wrong fitment or otherwise things, so there is no.
The fitment error is not.
Fitment error
You
is
accepted it.
Lordship.
So then what was the error?
Error was, my lord, the increment which was given,
You
which
must
was
have
they
said.
were not entitled, my lord.
Please show us that this was the error. Page 137 is your no, not page 137. That is page
137. That is the by virtue of.
And before that, my lord, we
the 137 is dated 21st October. So please tell us, Mr. Hussain, where you are rectification, where you are saying.
The order which is under challenge in the writ petition, my lord.
That is page 137. Then what is the defect according to them, sir?
According to them, the fitment was wrong done by the equation committee, not by the bank.
Where do I find that? Fitment was wrong by the equation committee. Where is that line?
Implementation of device basically. Current salary, arrear salary payment.
Kindly come to, you please kindly come to page 484, 482, rather 81. The facts are the government of India by 22nd February 91 had accepted recommendation of equation committee dated 16 January. Subsequently, NABARD issued the letter 20th March as instructed. Had address certain to the sponsor in the matter of implementation NIT or read with recommended as instructed by the government had address certain operational permission.
We have but page 481. Where
Page
481,
481, yes.
middle portion. This court finds that the case of the respondent such and
Yes.
such, and that recommendation of the fitment formula by the equation committee, NIT cell, as decided in their meeting dated 16 March 1991 was correct. The said respondent, however, contended that the clarification dated 30th April 1993 of the equation committee on reconsideration of their other recommendation for fitment of those proposed promoting field supervisors resulted in issuance of wrong recommendation of their fitment, second, third, and fourth
So
stage of
this
official.
wrong recommendation was of the
Equation committee.
equation committee.
Yeah, so they were that wrong was detected subsequently, and as a result of which they were getting which they were not entitled to.
But when the recommendation was erroneous, you could have challenged that recommendation through NABARD. You did not do so.
But that recommendation, I think, my submission of before Lordship, that NABARD has got no role to play here.
Chalo, the learned advocates appearing for the respective parties have concluded their arguments. Judgment reserved.
Is appearing for the railways, and my lord, I have.
No, in PNB matter, this is a part third matter, the last item in the lordship list. I am no longer appearing in the matter. Mr. Somitendra Datta is appearing for Union of India. I shall.
Who is private responsible?
Kullan Sarkar is appearing in this matter, my lord.
তো কি করি extend করে দিই?
Maybe extended, my lord.
Who is for the state?
For hearing.
We will release why we have kept it.
Lordship has heard me, my lord. I have concluded my argument, my lord. It was for the respondent, my lord, to conclude. My lord, I requested it.
এই অমলান ওই ফাইলটা একটু ওয়েট করো। Mr. Chakraborty, you are not
No,
there.
I am no longer appearing. Mr. Somitendra Datta is appearing. I was initially appearing.
You are omnipotent. You can appear in all matters. You can appear in all matters.
No, I can appear in any matter of government.
Exactly.
There is no bar.
Yes.
I need not seek the permission of anybody. That is true. But since the fact remains that I entrusted him to do the case, rest of the case. Initially, I was here. I argued. Now that this,
We will include it. We will give your appearance, Mr.
Very
Chakraborty, and we will, subject to your opposition, we will extend the interim order. And we will fix a date when we can. আসো দেখি এই স্যারের নাম দিয়ে দেবে।
for Union of India. For Union of India.
Sir, towards your listening to
No, no.
আপনি তো বললেন
Somitendra Datta, Somitendra Datta. এক্সটেনশনের জন্য করেছে এটা তুমি করেছো তুমি তো প্রাইভেট রেসপন্ডেন্ট
PNB, what was the issue in this, Mr.
No, there is a dispute between the petitioner and the bank regarding deduction of some amount.
Yes, my lord.
Ultimately, your lordships have been pleased to hold that Union of India has nothing to do in this case. It is bank is to answer before your lordships as to why such a
that
deduction.
enhanced pension.
That
Yes.
enhancement,
Oh,
your lordship.
I do, where you were not there on the earlier day.
Mr. Kullan Sarkar is appearing.
That you please ask him to appear. Na? How long we will keep it
And
pending,
fixed
sir?
date, my lord, that date, my lord.
Lordship.
He's also an old man. He wants his.
Next Friday, if you my lord sit.
আসো hardly learned advocates appearing for the
এটা নিয়ে নেবেন। And my lord, the Eastern Railways also filed a report, my lord. We have shown before your lordship, there was an instruction from the Eastern Railways also. They calculated it wrong, that is why. My lord, I'll place it on that.
All right. Yes, next.
Grateful to your lordship.
Yes, Mr. What happened? Your contempt?
My lord, we have preferred an SLP, my lord. No, sir.
SLP?
Very next matter.
Eh?
Nine.
Item 8.
8, my lord. I am for the applicants, my lord. My lord, this matter is
First
arising
time
from.
it has come. It has come first time.
Yes, I am
Contempt.
coming for contempt. This matter is arising from MAT 638, my lord. Rajiv Brahma's case, my lord.
Oh, we have
Violation
kept
of.
it on that date.
Yes. We are similarly placed, my lord, on 4th, my lord, this
এই
matter.
কবে রেখেছি 4 তারিখ
4th
না?
September.
যেদিন থাকবে ওদিনকে দিয়ে দিও ওই কি এসএলপি ওই যে স্কুল সার্ভিস কমিশন ওই দিনকে দিয়ে দিও
4th September 20.
4th yes
Service.
no no
I'll serve.
oh you have not yet served?
No, this is the first time.
oh আচ্ছা আচ্ছা the present contempt application has been preferred alleging
His lordship's
no,
order.
you were there.
Yes, yes. I have alleged contempt number 2, my lord.
My lord, we have ultimately we have
Oh,
we have
SLP, my lord.
SLP has
কি
been
এত
preferred.
উৎসাহ নিয়ে দেখাচ্ছে
SLP preferred in July, 26 July 2025, defects were notified, 1 month gone, defect not corrected.
No, no, I was told, my lord, the letter has been issued just, my lord, on 28th, my lord, we have received letter. It has been mentioned and expected to be listed
On
on 7th September.
Defect has not been cured.
I am not gone to
showing to the
Supreme Court. I do not
case
know.
report.
This is the letter which I have received.
Very well, madam, kindly adjourn for 3 months because after 3 months, if they do not record the defects, it will be dismissed automatically.
who has preferred SLP
State.
finance or judicial department
Judicial department. Number 2.
আচ্ছা।
The same matter, my lord, that handicap, 11 years, my lord, nearly 30 since the order of the single judge, 8 years since the order of appellate court. My lord. They are yet to implement.
Where is
the
your
order.
other side? Where is your other side?
I don't find them, they were supposed to give the scheme, nothing about it. Out of 6, 4 or 5 have retired, only 1 is working. Out of that, 2 have died. Nothing has been done, no implementation, nothing.
Don't say nothing has been done. You have been paid the
No, no, that
scheme.
is-
That
that is
you
what
may
I-
not be satisfied with, but don't say that nothing
No,
has
no,
been done.
I say, my lord, that I have to be given so far as the last 36
Hmm.
years is concerned and the pension is concerned.
Hmm.
That was the order, no scheme, nothing. If I accept, my lord, that the supernumerary that they have created is the part of the scheme, then give us that entire scheme. You cannot pass by, you have not neither challenged the order, nor there is a review of the order. We are.
You are in item number 10, na?
10, my lord.
Not 11.
10 and 11 are together. One is the appeal, the other is the contempt possibility.
Oh, I see. One is. Now, we find a review application has also been filed.
Review?
No.
Oh,
that's-
11 is yes. No, sorry. 10,
Oh,
10,
acha.
10 is ours.
Mr. Roy, give a notice to your other side. We are sitting on 4th. No, 9th, na?
Last order দিয়েছিল to take instructions.
They were directed to take instructions with regard to the pension and all that. They have not done. Yes. They have the responsibility at least to appear and inform the court. মেয়েটার নাম লিখে দিয়েছিস? Good. Contempt proceedings, till then they avoid the court, they don't give any report, nothing.
All right, Mr. Roy, we have heard you.
Yes, my lord,
We have
of course,
heard you.
we've heard it.
Ashok. Records reveal that by an earlier order dated 25th April, records reveal that when the matter was last taken up for hearing on that will benefit you.
I am for the response.
I am for the
No, contempt is the review app. Review.
Reviewers,
Review of what?
your lordship's order.
Yes, Mr.
Madam, your lordship's order is at page 145, madam.
কি ভুল করলাম?
Madam.
What wrong we have committed?
Madam.
145.
But this is review.
6th May.
6th May.
Review application কোথায় গো?
There is a-
You filed an application?
Yes, yes.
কোথায় সেটা? Review
Can 1 of
Can
2024.
1 can 1 টা নেই?
কেন লাগবে তো?
আচ্ছা, all right, we have the order. Tell us now what
Yes,
is
madam,
the
your lordship, madam, consent. Herein, my lord, petitioner, but first of all, the petitioner, my lord, it was not considered that the
Acha,
petition.
you give us 2 minutes. Let us.
Madam. Review petition আছে। Review petition। সেটা আপনার
So you are for the Shamol Kumar Hira?
Madam.
Oh, we dismissed your writ petition.
Madam.
Yes, tell us what wrong we have done.
Madam, that can is necessary because madam, I am to refer from the can. That my petition, what of it, madam?
Okay. Yes.
Madam, come. Madam, petitioner was directly recruited by the Railway Recruitment Board.
We are not on the main matter, we
Hey,
are
come.
review.
Yes, this is review. But now, my lord, if your lordship kindly come to page, then I'm directly come to page 3 of your lordship's also. Page 3.
Yes.
May I read, my lord? Mr. Chatterjee, learned advocate appearing for the respondents, vehemently opposed the contention canvassed by Mr. Dole. He asserts that in 1994, only 13 posts of head clerk fell vacant. Drawing our attention to the gradation list prepared for the clerk grade 1, he submits that 3 SC candidates who were senior to the petitioner had not been called for. He asserts that no employee superseded the petitioner and he was awarded promotion as per entitlement. But this is not correct. Because, my lord, petitioner was called.
That was his submission.
It is his submission.
Yes, called.
No.
You were called for the suitability test inadvertently.
No. I'm coming.
That is the finding. Kindly come to the next paragraph.
Next, my lord, I'm harping on you, your lordship. From the order of the divisional personnel officer dated 5th March 1984, it would be explicit that the later dated, but this cannot, because later 2nd April 1994, this cannot be, my lord, because this not later, whereby the petitioner was invited to participate in the suitability test was mistakenly issued by the subordinate officer, and as such, the letter dated 2/4/1994 had not been given effect to. This is not correct, madam. This is not
because
correct.
the letter is of a subsequent date.
Yes, because subsequent date, because this cannot cure, but later date.
No, what did we say? From the order of the divisional dated 5th October 5th March or August?
This is March, my your lordship. This is March. Dated 5th March 1994. It would be explicit that the later dated 2nd April 1994, whereby the petitioner was invited to participate in the suitability test, was mistakenly issued by the subordinate officer, and as such, the later dated 2nd April 1994.
So show us the 5th March letter.
Yes, madam. Yes, madam. Kindly page 39. Page 39 of Can 1. Page 39.
Page 39.
Page 39. But may I just may I draw your also page 37 first. 37 first.
Yes.
But page 37 first, then I will come.
30?
37. Page 37.
Page
37. 37.
30th March 94.
That's I'm coming. Yes, 30th March 94. But I'm reading. Holding of selection test for the post of head clerk in scale sciences and clerk grade 1 scale sciences. This is the fact, man. Can see for the post of head clerk. But what happened? The petitioner at that point, petitioner was appointed clerk grade 1 directly by the Railway Recruitment
We are
Board.
not on that. Your argument, if we have understood, is that we have said that from a letter of 5th March 1994, the court found that he was called to participate by a letter dated 2nd April. This cannot be.
Cannot be. This
That
cannot
is your
be.
argument.
Yes,
na?
this cannot
So
be.
please show us 5th March letter first.
Madam,
5th March letter
Madam,
first.
this
Yes.
page 39.
That is page 39. Please, theater.
Madam, holding of test for the post of head clerk, clerk grade 1. In partial
reference is a letter of 30th March.
Yes, reference 30th March, I want to show a lordship.
We will come to that.
My
Please read it.
Yes. In partial modification of this office letter of event number dated 30th March 1994, the name of Shamol Kumar Hira SC under Sansas, who has been called to appear for the selection test for clerk grade 1, is to be deleted from the call list mentioned under reference, and instead the name of Sri Hiralal SC clerk grade 2 under Sansas is incorporated in the said call list the census, because it was inadvertently later dated 30, if you also can come to page 37. 37. What happened, my lord?
আমরা বলেছি লেটার ডেটেড 2nd এপ্রিল
ডেটটা second April, page 40 2nd April later. Now page 40 2nd April later, page 40. But before that, if you also can come to page 37, because this refers.
In terms of your request, direct the following 9/4/94 এ suitability test হবে। এই চিঠিটা was erroneously issued. You want us to come to page 37?
Well, this is my lord. Next, come to page 40 now. What your lordship first order.
Page 40 is a letter of 2nd April.
Yes. Can come to
by
2nd
this
April.
letter, you were called for a suitability test on 9th of April 94.
Yes. By letter dated 2nd April 1994. You lordship refer this, my lord. You wanted to say, my lord, so far I understand that by the previous letter, my candidate was cancelled. It is not, my lord. Because I was not called initially, because I was teaching.
So it was cancelled by which letter?
By
page 37.
No. My
38.
name was not placed in the.
Now, let us understand. 2nd April 94, you were asked to participate in a suitability test on 9th April.
Yes.
Now, the 2nd April 94 letter, was it cancelled?
No.
In 5th March 1994, it was stated that although in partial notification, the name of such and such has been called for to appear in the selection test.
But that was mistakenly done.
Is to be deleted.
Yes, because
is to be deleted from the call list mentioned under reference. And instead, the name of one Sri Hiralal SC is incorporated. That means this is and deleted and incorporated.
Yes.
And hence,
yes,
since it is done on 5th March, this letter was erroneously issued.
Yes, that is correct,
because this letter was issued divisional personnel officer. Who issued divisional personnel officer?
Yes,
and this letter, who issued this letter?
Divisional personnel officer.
No, 2nd April.
2nd April subordinate officer.
A subordinate officer.
No, not that. I'm coming. Can you hear me? What happened? Page 37. My name has been put. I'll come to page 37. My name is figured as clerk grade 2 for promotion to clerk grade 1.
What is your name?
Shamol Hira.
Shamol Kumar Hira. My second clerk grade.
Serial 10.
Serial 10. Bottom. Serial
What
10.
is this letter?
His status has been mentioned clerk grade 2.
Holding of suitability for the post of head clerk.
But he is all no.
Decided to be held on 9th April. The following eligible candidates therefore advised to appear. Now,
what
on the basis of this letter, 2nd April letter was issued.
Let me clarify this. But my name was mentioned here as clerk grade 2 for promotion to clerk grade 1. I was in the clerk grade 1. My name should have been under clerk grade 1.
But I am, this is the mistake. That's why that has been rectified. That my name has been mistakenly written as clerk grade 1. My name is Shamul Kumar Hira. It is mentioned that I am to get promotion under clerk grade 1, but I am at that time I was
You were substituted by one Hiralal.
Hiralal is clerk grade 2.
We are not on that. We are saying that we have rejected your claim because your suitability examination you could not participate because it was cancelled.
No,
Name.
no. Again, I'm trying to understand.
We are failing to understand.
No.
Don't go in other issues. You address that by this letter of 5th March 1994.
Yes.
This letter was issued dealing with a letter of 30th March 1994. How
Yes.
can it be?
Yes. How can it be, Madam? This is
এই ডেটটা ভুল আছে
Yes.
This date is not proper. 5th March date is not proper.
it is how it can be, Madam? 5th March.
On 30th March, one list was published. On 30th March, one list was published.
No, this mistake.
You forget about the date.
List was
And initially, one list was published declaring that these candidates are suitable and hence they are called for and advised to appear on the written test to be held on 9th April. Subsequently, divisional personnel officer says the name of Samuel Kumar Hira was erroneously incorporated.
In the list dated 30th March. 30th March, my name is incorporated, my lord. Serial number 10. It is
That
under
mistake which has been done by the department.
This is the mistake done by the department because my name should have been under first paragraph under my grade 1. I am to
Why didn't you point it out at the time of hearing?
I was not there.
You didn't tell us.
No, I was not.
Then how can we allow you to re-argue the matter?
This is the thing which I am.
If your case is that your very incorporation under clerk grade 1 was wrong, you should have told us that.
But I was not. This is the matter.
Whether this
This letter date is immaterial. We are proceeding on the letter date. Maybe a typographical error was there. I don't know. How you could have said? You take instruction.
I will take an instructions regarding this letter. I will take an instruction regarding this letter. But whether this court can sit in a review or this is an fit case for appeal, that's the question. Whether
That we will consider. Your officers will not teach us. Your officers will give you only instruction. Come with the instruction, then we will hear you. Whether we can review or it can
whether it can be an appellable or not.
Mr. Royal, the present application has been the list.
No, if it is 10:30, then
Yes.
All will just yeah, I have filed a review petition in
Milord, before your lordship rises, Milord.
Out of station at the time we shot.
No, Milord, this
You're out of station.
no, Milord.
Huh? Or your juniors mentioning was not allowed.
No, Milord. This is one matter is listed, a contempt matter is listed. We have filed a review that is to be listed along with.
Which one?
Item number 33.
33. 33. It is a fresh content.
33.
Yes, ma'am.
Appellate side.
Appellate side, item number 30.
Yes, what you have filed?
I will review application.
After they said before us, we are complying.
Well, kind of the next day.
How can that be here now?
Least होते आपत्ति होता है.
No, no.
Let's check.
No. What persons are these? They don't speak on instruction or what?
No, well, issue is, my lord, I think what they are saying, my lord, even if he is granted the benefit, if the findings stay, my lord, it will create problem in other cases.
That we can consider, but
That
you
is-
have
that
not,
is the only
but
point.
you have not disbursed as yet.
Possibly.
No,
Not disburse the full amount.
I am
no?
not appearing in the contempt.
He is there. The client is here. You have not disbursed.
He has not been disbursed. What is happening,
Entire-
sir? One Mr. What name? Nilanjan Bhattacharya appeared. He said that please. Yes, about you.
May I?
You cannot talk. Wait. Nilanjan Bhattacharya appeared and said we are complying. Give me 1 week. What is this?
And he said he's going to settle the matter with me, sit with me, and do the needful.
Okay.
Mr. Bhattacharya gave words.
এটাকে to be mentioned দিয়ে দেবে তো? We are keeping it as to be mentioned. On that day we will send them.
My lord,
Let the review matter be listed.
Who you are for the alleged contemners?
Yes.
Then, for whom Mr. Bhattacharya is
I am appearing in the review petition. My instruction is to file a review petition.
So very good. Review.
And my lord, separate set.
Review. What we can understand. You say that review is not to treat it as a precedent. That may be your.
Ultimately, I will pray for that.
Maybe that. But then why the pension shall not be released?
Not have any. Malab, we have been.
You are appearing for the same officer and you are saying.
Malab, we had told them initially we were under the impression that we will be appearing for.
So very good. You ask your officer to be personally present of that.
My lord, they from very beginning, my lord, from Supreme Court and everywhere.
Sir,
they're doing the same thing.
don't make it further. We are already agitated about
My
it.
lord.
Where is Nilanjan Bhattacharya? Nilanjan Bhattacharya's junior is here. একজন ভদ্রমহিলা ছিলেন না?
We shall inform, my lord. Kindly passes, we shall inform.
এইটাকে তাহলে ওই 12 তারিখ এই item number. And all your officers used to be present on every day. We remember because 3 of them used to come. And we told them that is it a fact that you have forwarded it and it will be released? They vouched that we have so done. We have so done. It was something pro forma application was not being tallied or something like that was told.
The Bhavishya Nidhi, what was not working.
Wait. So we said that all right, we are keeping on that day. You have not preferred SLP was dismissed.
Yes.
Please intimate the
Yes, sir, I will tell them.
they're not properly acting.
I will tell them what has happened in court today.
And you please inform Mr. Nilanjan Bhattacharya also. ওইটাকে 12 তারিখ to be mentioned করে দেবে along with that review application যেটা দিয়েছে. Yes.
my lord, item number I have mentioned at the time of sitting, my lord. My lord, the AAG is appearing on behalf of the contemptor along with Mr. Tapon Bhanjo.
What do
They
you
were
want?
present.
You want what order from us now?
My lord, kindly takes up this matter under the heading to be mentioned next sitting date. That is all of my.
You are appearing.
My lord, Mr. Tapon Bhanjo and Mr. AAG.
Matters we can.
My lord, I have intimated they were my lord, the AAG, Mr. AAG is here, my lord. My lord, sir, একটু
ওটা আপনি মেনশন
My lords.
Because of the pendency of the SLP, which was delayed, they were kept in a separate heading under the merit list. Since the SLP was dismissed, I advised them to bring them under the merit list and their candidature is being considered for appointment. This is the latest instruction. If my lords want to see, we shall produce on the next day.
Then what is the problem now? Then you have decided, as per your advice, you have said that you create a.
Your lordship judgment was that in the event they satisfy all the requirements,
I
all
see.
tests,
I see. Yes.
they shall be placed under the merit list.
Very good.
There is no direction to give appointment. But since I advised the Director General of CRPF not to prefer SLP, to comply with your lordship's order, but they, for abundant caution,
They
prefer
kept
the
them.
SLP.
That's very good. Now,
And during the pendency of the SLP, these people who are filing application for contempt, they were kept under a separate list. Since the SLP was dismissed, they were brought under the merit list. Merit list now,
if they come within the zone of consideration,
they shall be given appointment.
Very
Yes,
good
my lord,
problem
we
solved.
are coming under the zone of
So
consideration.
we cannot go beyond the order which we have passed.
My lord, you,
Our order was that if you are emerged to be successful, you will
Yes.
be kept in a merit list.
yes,
We didn't say that after that you should be given appointment.
my lord, the person who are selected, only that list has been published by the respondent authority.
Then you will get
For
job.
keeping up.
That is
Get
My lord,
that is
what
sufficient
problem
compliance.
is that, my lord, if in the meantime 1 year passed, then we shall again face the review medical examination.
No.
This
They
is the procedure.
If you are selected, how you will be again?
Yes, that is the problem. This is the
That
procedure.
Mr. Chakraborty what he's saying.
No, I
That
don't
is the
find,
problem.
I don't find from
We
the
are
communication-
apprehending that we will face
Sir,
the
Mr.
again
Chakraborty,
medical
from
exam.
the communication that the merit list is life is for 1 year. The merit list has been prepared after the dismissal of the SLP. And we have communicated to SSC also,
SSC also intimate us that their withheld has been cleared.
and
Process to be-
SSC also intimated us that the withholding of those candidature has been cleared. They are considering the issue. Therefore, your
Now
lordship will hear it on next day.
We will record and dispose of what.
Yes,
we
that is the thing, my lord. I am
What that is the thing.
my lord, your lordship passed an order. My lord, now we are on the verge of giving appointment. That is the thing.
No, he wants.
Have we said give appointment? We have said you will come in the merit list.
My lord, merit list, they have not published any merit list. They published the selected candidate.
Right.
list.
What is the problem?
We are already come under the said zone of consideration. Now they are comply to issue the
If we
appointment.
find that it is nothing wrong in that, then your clients will be in problem.
My lord,
You are instigating the court to say something. It is apparent from the face of the records that it will be done. You are unnecessarily disturbing the court. Then. We will keep it. We will. Item number কত কত?
my lord, 32, 31, 32, 35, 36, 40, 41 and 43.
These are the
That
items.
7 men.
ওটা কি আলাদা আলাদা অর্ডার হয়েছে? হ্যাঁ? অর্ডার হয়েছে আলাদা আলাদা?
Yes, order is being passed separately.
একটা যে কোনো একটা দাও অন দি
কি বলবো?
তাহলে অর্ডার দিতে হবে না। তুমি
Yes.
টু বি মেনশন ডে 12 তারিখ রেখে দাও।
SSC কোন?
একটা গ্রুপ করে কটা হচ্ছে? সেগুলো মনে রেখো তারপর আমরা সাজিয়ে নেবো। নিচে। 12 তারিখ এটা কবে রেখেছে? না এটা তো আফটার ভেকেশন রেখেছি। এটা তো নভেম্বরে রেখেছি। এই যে টু বি মেনশন ডে যেগুলো ছিল, এই যে চণ্ডীচরণ দে অ্যাপিয়ার করবে নভেম্বরে রেখেছি। আচ্ছা তুমি চেক করে নাও না, সেরকম ইয়েতে আমরা তুলে দিয়ে মিস্টার চক্রবর্তী we are keeping us to be mentioned on 12th of this month on
September.
12th. On 12th we are keeping, you come and tell us.
Obliged.
You were saying another test is going to be held.
No. Medical exam. If in the meantime, from the date of medical
1
exam.
year when it will expire.
Yes, my medical examination was done on 10th to 12th December 2025. 2024. And if we are not being sent to the
one year is there, na?
yes,
So 1 year period has not lapsed.
no,
So
till
if
date
we are
not.
taking it on 12th.
Yes, That I am not saying that today itself your lordship take up the
Lord, may I have your lordships?
Before your
Lord,
lordship.
may I have Lord, may I have your lordships? 1 minute.
Would it be lordship's pleasure to record an order that it will appear as to be mentioned on a particular date?
There are many matters now, সব কি আলাদা হয়েছে? আসলে হয়। As prayed for by Mr. Chakraborty Learned, Solicitor General is the matter as a
Additional.
Additional solicitor. Learned additions are appearing for the alleged contemners. Yes.
Contempt.
Not all, no.
Please the matter for further consideration on 12th, no? 12th September
করছি না তো।
under the heading to appear in a daily supplementary list of this court on 12th September under the heading to be mentioned.
My lord, I am appearing for alleged contemners with regard to the paramilitary force officers, not SSC. Whether he has served
Yes,
the
I have
SSC or
the.
not.
This is I have the service affidavit. I have served and they have received the track.
You are appearing for whom, Mr. Chakraborty?
For alleged contempt number, you say alleged contempt number.
Alleged contempt number. কোনটা ছাড়া?
Hey,
1 and 3. Oh, only 3, only 3.
তাহলে ওরম বলে দেবে,
Alleged contempt number 3.
he is 3 in all the matters.
Yes.
Yes, 3 is all the matter.
তাহলে as prayed for by Mr. Chakraborty Learned additional Solicitor General appearing for the alleged contender number 3, comma, please the matter for further consideration on such and such in the daily supplementary list of this court on such and such under the heading.
And my learned friend will serve another notice to the SSC contempt.
My lord, I have served, they have received. This is my affidavit of service. My lord, SSC, Delhi and regional office also.
Affidavit of service as file be kept on record. In all matters.
Yes, all matters I have served, I am handing over all the service and they have received. I have got the track report also.
Heard Mr. Kundu Learned Advocate appearing for the petitioner.
Yes.
September.
Any advocate engaged, do you know?
I cannot say.
So you intimate this to the.
My lord, I shall serve again another notice to the SSC regional office and the Delhi office.
As no one appears on behalf
Intimating
of the alleged contender numbers
1 and 2.
1 and 2.
1 and 2. The SSC chairman Delhi and deputy director regional office.
In spite of service, no one appears on behalf of the alleged contender numbers
1 and 2 of all matters.
1 and 2. So Mr. Chakraborty, you can appear.
SSC, my lord, they have a separate panel.
1 and 2 is 1 is
Staff
SSC,
Selection
staff
Commission.
selection.
Staff Selection Commission, they have a separate panel.
আচ্ছা, তারপরে ওই বেঞ্চের লাস্টে ওই কুন্ডুকে শুনেছে, তারপর লাস্টে লিখে দেবে ওটা তো উপরে দিয়ে দিলে তাহলে এভিডেভিডেও সার্ভিসটা নিচে রেখে লেখো, উপরে মিস্টার কুন্ডু করে দেবে, মানে তারপরে মিস্টার চক্রবর্তীর ওই প্রেয়ারটা দেবে, তারপরে দেবে লেট দি এভিডেভিডেও সার্ভিস in spite of service, no one appears on behalf of the alleged contender numbers 1 and 2. Stop. Let this affidavit of service, comma, as placed on kept on record. Stop. Mr. Kundu is directed to intimate this order to the said alleged contender numbers 1 and 2 and file an affidavit of service on the return.
Much of
Lord, it made returnable on 12th September.
And before your lordship's right, may I mention item 13, review application for the first time. Your lordship kindly direct service of notice and come back on it.
Item
13, 1-3. Review application.
একটা একটা করে বসে সব তো তারপর ইয়ে হয়ে যাবে। What is the problem? We will take it up next day. You serve, serve. No, it is called contempt.
It is not content.
Pardon?
one line order.
My lord, item number 47, I am only the extension
47 and 48.
is expiring this month, your lordship.
Pardon?
May I have your lordship's kind indulgence to mention?
So
I am
Vasu,
being
your
led by
junior
Mr.
is here. If I refuse here, we will hear.
Yes, yes.
My lord, the interim order in item number,
It is shown, huh?
my lord, in item number,
If your other side,
my lord, I have already intimated them. The interim order is expiring this month, your lordship. That's why I am mentioning, your lordship.
this is the last. Who had been your other side?
Mr. P.R. Das,
48, there is no interim order possible. 47, there is no.
my lord, I have already informed them by way of a mail. your lordship.
কি করে দেবো বলো?
Didn't maintain at 2 p.m.
But 2 p.m. where were you?
Yes, your lordship.
2 p.m. you did not show. So many matters we have kept it and you were not there. Extension of interim order matter was mentioned before us.
2 p.m. also.
Your senior is online and you are off totally. And you expect us to pass the extension as you desire.
Other side it appeared.
Item number 47, your lordship.
Teaching as a test list. Teaching as test.
No, no, this list to have like that.
ও আছে হ্যাঁ 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 তাহলে করুন
In 48, there was no order interim order.
উড়িয়ে যাচ্ছে
তিনটা ভাষা আছে বলতে
আমি কালকে মাস না আজকে কত তারিখ জানো 28 হ্যাঁ কালকে
Why didn't you mention at the when we sat?
My lord, we thought that the matter will be called on
47 and 8
47 and 48.
no no
Interim order is only in respect of 47.
একসাথে হয়েছিল
47 and 8 লেখা আছে
আউট অফ টার্ম নিয়ে আমরা এক্সটেন্ড করব
কালকে এই মাসের শেষ দিন কালকে
Why should we extend, sir? You didn't mention it that it is going to expire tomorrow. Matter is in the list, it may not be reached. Have you seen
Sir,
how
it's
many
running
advocates has mentioned?
You are under the impression that the matter will be
Please
called
don't
on-
give excuses. You failed. Please don't give excuse. সাড়ে তিনটে বেজে গেছে ইংল্যান্ডের ইচ্ছের জন্য তোমার সাথে কাল কি করে বেঞ্চে বসবো
কালকে বসলে তো কোনো অসুবিধা নেই কালকে তো
আজকে কত তারিখ
না হলে ঘুরিয়ে যাওয়ার পর এটাকে রিইনস্টেট করে
রিইনস্টেট করে 29th আজকে আজকে 28th
আজ 28 কালকে 29 তারপরে
What about the Supreme Court matter?
It is still pending, your lordship. It will next be listed on 3rd of September, your lordship. This is the last order.
The learned advocate appearing for the petitioner. দেবে না হতো এই লিস্টে দাও না ম্যাটারটা লিস্টে দাও Records reveal that when the matter was earlier taken up for hearing on 11 July 2025, no one appeared on behalf of the respondents. On behalf of the respondents. Stop. The learned advocate appearing for the appeared the learned advocate appearing for the you are the you are the Ratan Kumar.
No, your
Oh, you are BSNL.
I am BSN.
Mr. Basu is BSNL.
Yes, your lordship. Mr. Basu is leading.
Appearing for the writ petitioners submits that the you preferred special leave petition against which order?
Against that order, your lordship, that Tapan Kumar Das, similar points were involved over there. They have prepared an SLP from that Tapan Kumar Das's order. Similar
But this is
your
preferred
lordship.
by you, SLP, Bharat Sanchar.
Yes, your lordship. Against the matter of Tapan Kumar Das.
In that matter, the Tapan Kumar, that is not before us.
Not before your lordship, but similar issues are involved. Your lordship. Exactly similar issues.
That's no order. Today, Kirike. The interim order having for the petitioners is for extension of the interim order earlier passed in the writ petition being WPCT 58 of 2020, which is due to expire on 31st August 2025. Stop. In view thereof, stop. List the matter for further consideration in the daily supplementary list of this court on 12th September. Stop. The interim order passed earlier is extended till extended till 15th is extended till end of November. Till the end of November, in the end of November 2025, or until further orders, whichever is earlier. Stop. The petitioners are directed to intimate this order to the respondents within a week from date and to file an affidavit of service on the returnable date. List the matter for further consideration 12. If you don't serve, we are vacating your interim.